Right, good morning everybody. It is now 9:30, so it's time for the inquiry to resume for the last time in this tranche, as it were, until October. So let's make this a good day. First of all, usual announcements. First of all, could you please make sure your mobile phones are switched to silent? It's probably quite important with so many people in the room. Secondly, if we hear the fire alarm, we have to go out of one of the two main fire exits. Could you sit there, Miss Bonnie, please? Thank you. And we congregate, we go downstairs, congregate in the council's car park. Obviously, we don't come back in the building until we're told it's safe to do so. Everybody all right with stairs? Yes, everybody? No problem, right? Okay, thank you very much. Now, just one or two things before we start. First of all, the site visit we mentioned, do you remember? I suggested possibly the week after next, and you were going to go away and have a think about it. Have any thoughts been crystallised? Mr. Gearing.
Yes, I've spoken to Swale Borough Council. Mr. Diagon's away, but there are other people at the council who can attend, so we're completely happy with that week. We just need to liaise with you on the best day for you. Right,
what about you, Miss Bonnie?
Sorry, yes, I have contacted both Shooting Box and Bexon. As soon as I get a response, I'll let you know.
All right, so it's the week after next, if it's talking.
I might have a response today, so hopefully.
Okay, I hope so.
Yeah.
Yes. Right, it'll be a lot easier to organise if we can try and do it before we leave, won't it? All right, we'll come back to that then. Now, as far as I can see, there are two outstanding documents. I know they're not necessarily going to be handed in today, but just to focus on what they are. First of all, Mr. Young, yes, you were going to respond to Mr. Simons next week, I think you said.
That's right, yep.
And also, there was going to be that joint note of Mr. Spilsbury and Mr. Mitford-Slade, wasn't
Yes,
there?
we've started that process, yeah.
Right, okay. So is that next week, do you think?
Yes, I should think so, yeah.
Now, I don't think there's anything else, but has anybody got a note of anything else that we're due? The which? Oh, go on.
Morning, Madam. As you recall, there has been various comments on the plans as we've been going through the inquiry, and the architects have been updating those. We've also introduced a little bit more flexibility to accommodate the requests from the NHS as well. If you recall, there was discussions about whether a larger NHS facility could go in the south. So we've been some minor changes we've made to those. We've been discussing those with the Borough Council. We'd like to submit those today if that's possible. We've got hard copies to hand out. We thought that would be useful to do before we broke, rather than wait until October.
The only thing is we do need to, I think people need to know what the, say, minor changes, exactly what they are.
There is a schedule with the plans that goes with them, so we've got hard copies with that schedule for both sets as well. So.
Okay, well obviously I have to decide whether I'm going to accept any changes, and I'm not going to do that today. Okay. But we will be able to discuss those in the planning session when we meet again in October, so everybody's got a good chance to look at them. And if you have got any comments, then I suggest you perhaps commit them to writing, and then we can consider them. But you say it's minor. Well, I just want to to have a look, obviously, just to see what's what.
Yes, we've got them now. Should we hand them out? We've got hard copies for all the parties.
Thank you.
Yeah, over there on there.
Mum.
Yes.
So if I pick up on that first and then I'll come back to the site visit. So, that is critical. We understand that now because obviously that has a implication on the Section 106 and obviously any phasing and delivery around that. So I'll park that. I won't make any further comment other than that.
You mean the 106 in relation to the NHS?
Because but it could have implications on other bits of the Section 106.
Not for today.
No, exactly.
Thank you. Yes.
But it's quite difficult to talk about transport in isolation when there's other moving parts. The other part, site visit, I just want to check before I blurt it out loud. I just got an email in. So we're talking Wednesday the 6th of August. I've just got a response back, and the times they've...
Not too early, because I'm going to have to be... I'm not staying down here, so...
No. I think they're quite flexible. Let me just check on the top
It could
here.
be
So,
sort of-
avoiding lunch hour. So
Okay.
anywhere between 9:30 and 5, avoiding lunch hour, which is 12 till 1. And
Is this the nursery?
that's the nursery. They can, if we try and do them both on one day, I think Wednesday, the 5th. I just need to check with Bexon on that one, but
Okay.
that's...
You
Sorry?
said the 6th.
Uh,
The 6th of August, is it?
the 5th.
The 5th.
5th.
Right, well, I haven't
It's a
got my
Wednesday.
calendar. What-
Tuesday's the
sorry.
5th.
Oh, hold on. Wednesday the 6th. I think, right, hold on, let me clarify. I'll come back to you in the break time because they've got their dates round the wrong way and I don't want to commit them.
All right, well...
So we'll hopefully have an update by this afternoon.
yeah, I mean, I would think that we could do it early afternoon then, say go to the nursery at 2, and then Bexon after that, and then finally the chalk pits, if that's okay, Mr Gearing.
Yes, we can arrange access at the same time so we can do the visit concurrently.
Yeah, I mean, as presumably access, it won't matter when we go to the chalk pits. I suggest we do that at the end. So,
Clarify just to make sure there's no switch, because that one's said Wednesday and the other one said the 6th.
no, okay, well, I don't mind Tuesday and
Yeah.
Wednesday, but if you could suggest that maybe we go to the nursery at 2 o'clock, and then Bexon, I don't know how long, after that, if they can be a bit flexible, that would be helpful. And then we'll just have to arrange where we meet. I mean, it would be helpful if we could have less cars, really, than everybody.
We
Well, I don't know who's going to be there, that's the only
can
thing.
walk from where the science park car park is up to Shooting Box Nursery.
Yes, okay, that's fine.
And then, I mean,
we can meet in the Science Park car park then, probably is the best
yes,
thing.
it's round the corner.
Yeah, depending on how many you are, we may be just about to jump in one car or
Whatever.
work that. I think we can work that out.
We'll sort
Yeah.
that out. on the-
And I would before we go just like to know who's going to be there as well.
Okay.
All right, so
So from our side, I think it'll be myself, Ben Gearing. I'll swing to Matt. I
Can
think
you-
it'll
can-
be
are you all right with
it'll
all
be
this?
Ian Harrison.
That'd be my boss, Ian Harrison.
oh right, okay. Oh yes,
I'm away.
yeah, that's
It would be me from 5 parishes and Beverly from the action group.
yeah. What's your surname?
Smith.
Smith.
Smith. Beverly Smith.
Thank you. So it's just the 4 of you, really, is it? No one else? I don't think anyone else is. Right, okay. Yeah, we might be able to just go round in one car then, mightn't we? Thank you very much. Okay, just the time and place then. We'll just confirm a bit later on. Thank you very much. Next thing, as I said yesterday, can you and at the end of today, please, can you hand in your building passes, either to Helen, or put them in the. Or do you want them anyway?
No, because I think they need them to go downstairs through the door and then...
I was just thinking, okay, don't forget then, just the post box just through the door that you go out of at the side, okay? If you could do that, please. Otherwise, I think we might have problems getting more passes in October. I think that's everything. Oh, we just got some new conditions, didn't we, from Mr. Dygan? Thank you. They're updated or...
Yes, they are. It's just I appreciate the lateness of the circulation, but if there is time, that'd be great.
I doubt whether we'll get to them, but anyway. Okay, thank you very much. And could you just make sure, please, that Helen's got a list? So we just want everybody's names on it who's here, so that I know who's sort of participating in the round table session or attending it. Okay. I find it quite difficult to remember names, as you probably gathered. So when I do know, obviously, that the people that I know some of you quite well, I know, but some of you, have popped in and out. So if you've got something to say and you don't think I know, you could just say your name, please. That would be really helpful. Right, now we have Network Rail here, don't we? Where are you? Yes, you're here. And you obviously aren't very involved in much of this. So I think we'll deal with your items first. And as far as I can see, the two items that we're... now, I'm not going to look at the new Section 106 that I was given. I'm hoping that the highway issues or the highway obligations are the same. I don't know whether they are or they aren't. Okay, so is it just the covenants relating to Sittingbourne Station and Teynham Station that you're interested in?
It is. We've obviously got the link over the railway as well, which I can provide sort of a comment on.
Right, okay. Well, someone will have to just point me to the right bits in the northern... Let's start with the northern Section 106 then. So could someone just point me to the bits about... hold on a minute.
For the northern scheme, ma'am,
Which covenant is it that we're looking at?
so if I just start with the covenant itself, but then we'd probably need to just track back to the definition. So if you go to the final page.
Yeah. This is the bridge itself, isn't it?
Uh,
I see. We're going to talk about the contributions
The
first.
contribution,
Oh, yes. All right.
Mr. Hatton was just going to make a comment. There's nothing in the Section 106 about the bridge itself. He was just going to clarify Networks Rail's position.
Okay, right. That's very helpful. Let's talk about the covenants first then. So the station contribution, which the Sittingbourne Station one is in the northern
That's right.
one, isn't it? Hang on, just a sec. Let's get that. We're jumping around. Yes. So I wasn't quite sure. Well, we haven't got anything about the sort of when it is to be provided. It's linked obviously to occupation, isn't it? And the sum itself. Where are we? Sittingbourne. The sum itself is £169,000, which would go towards secure cycle parking. Yes. So the two questions I need answered are, first of all, how you've come up with that sum, and secondly, how has it been decided about the proportion of dwellings to be occupied before it's paid, and if so, what the justification for that is? So I don't know. So could you just give me your name, please?
Yes, thank you, Mum. Yeah, Craig Hatton for Network Rail.
Sorry, Mr.
Hatton, Hatton.
Thank you.
Yes, as far as the Sittingbourne Station contribution is concerned, so the figure that's in the Section 106 is what's been quoted to us by our preferred supplier of cycle storage facilities that we use on the Kent network. So that's a cost that we recognise as being one that fits other similar size schemes. And obviously from our perspective, having that index linked just to ensure that covers the cost as time goes on would be beneficial. So that's where the cost comes from.
And is that a cost of the actual provision cost?
Yes, the actual construction of the facility.
Okay.
And in terms of the sort of the trigger for this, so at the moment the cycle facility, which is just located on just off the forecourt of the station, is generally at or close to capacity. So obviously we recognise that this isn't the opportunity to remedy existing capacity constraints. However, our concern is that any additional use from the potentially consented development would stretch the the capacity and the condition of the facility significantly. So we would be seeking the contribution to be paid at some point pre-occupation of any dwellings of the development.
Of
to
any
ensure
at
that
all?
we get
Well,
provided.
of any at all?
Yes.
Applicants want to say anything about that?
I don't think we've yet had any discussions on the timing for that payment, but certainly our expectation was that there would be a phased approach to that payment. It seems unnecessary to require that all up front, because surely the capacity issues will become more severe as the development progresses. I'll hand over to Ben.
Yes, it might be helpful. I've had discussions with Mr. Dygan and Mr. Hatton about this, and I think I can understand the comments they've made that essentially it's a single investment of improvements. So there is an upgrade and improved facilities there. I think we just need to have some more discussions on the exact trigger point. I can see why it would need to be early, but perhaps prior to any occupations, maybe a bit soon.
So, can I just ask you then, Mr. Hatton, are you're proposing to actually build more cycle racks, are you, or are you just upgrading what's there?
So we would replace the current facility, which is basically just a shelter, and it would provide additional racks to provide additional capacity from the new development, and it would also be fully lockable. Where it's located at the moment, it's publicly accessible, so providing a secure facility in which people can lock their bikes away will just provide confidence that they'll be able to store them safely for when they return.
So when you say so at the moment, I will go and have a look. I haven't actually seen, but I mean, so it's at the moment it's just a shelter, with something you can padlock your bike to.
Yes, so it's got sort of the racking on two levels, and you just put your bike in and you just put a lock.
So they are proper bike storage.
Yes.
things.
Yes.
But why aren't they satisfactory as it happens now?
So they're not satisfactory on the basis that the use of them is quite high at the moment already.
Yeah, I know, but you said that you wanted to
it's-
upgrade them.
So if somebody could just walk in off the station forecourt, and if they had the means could cut the bike locks and take the bikes away, what we're proposing is to have a proper lockable door on the facility.
Oh, I see.
And then any users could obtain a key, and that would just provide them with that added bit of security. And it would also provide additional capacity.
So you're not only providing more security, but you're going to provide more storage facilities.
Yes, that's correct. And we'd also be looking to just move the facility slightly, not far from its existing location, but just to create a potential drop-off place for any sort of shared bike schemes that come forward, just to prevent them being sort of left on the station forecourt in people's way. There'll be a designated area next to the new cycle store where they could be put.
You mean like these Lime bikes?
Yes, yeah. So instead of just being left outside the station entrance, there could be somewhere where they could actually be.
Are there already facilities for that? Do you have a Lime bike scheme or anything like that?
We don't at the moment, no. So this would be, so this would just be providing that extra space for them to be able to put them. It wouldn't be in the new cycle store. It would be adjacent to it, so it would still be open for people to come and use. But it would just save people potentially just leaving them outside the station entrance and making it difficult for people to access the station.
Okay. So, in terms of the phase when the payment's going to be made, then that's a matter that's going to be under discussion, is it?
Yes.
I think it's understood now that it would need to be a single payment because it's one facility, but it's just a matter of exactly when
I
that
see.
would be
Okay.
provided.
So it's just when that you.
Yes.
Okay. Thank you. Anything else to say on Sittingbourne Station?
No, the only thing just to confirm is that yes, it would have to be in a single payment. It couldn't really be phased, just in terms of how it's delivered.
but the question of when is something you're discussing. I know you want
we
it up
can-
front, but
we-
they
we-
don't
we-
want to
we
pay
can-
it up front.
We can discuss that, yeah.
Yeah. Okay, thank you. So Teynham, let's turn to that, and that's actually slightly strangely in the south, isn't it? So can you just explain that why? Because I was looking for it in the north, and of course it wasn't there.
That's on the basis that most people, we expect, will use either Faversham or Sittingbourne stations because they have access to high-speed one. Teynham obviously provides a rail service, but it's a much slower service into London. And there are sort of existing facilities there that are able to accommodate existing use and likely use from the northern site. We are just working on the basis that the southern site coming forward will still increase use of that station to some degree, and that providing an improved facility at Teynham would facilitate that.
Yeah, I mean, the slight problem is that, of course, these are separate applications with separate legal agreements, and I mean, it probably wouldn't matter so much if both of them were allowed, or even, although it would really, because it wouldn't really fit with the regulations. But if just the northern one were to be allowed, then obviously you wouldn't get anything for Teynham Station, and that was one of the points I think that was made in the sustainable transport strategy, that there was to be a cycle route and pedestrian route through the site and up to the station. So I would have thought it's quite important to think about how you're going to deal with it in the legal agreements to accommodate both of those scenarios. So yes, Ms. Bonnie or Mr. Townsend.
I'm not going to say it is. Good morning.
Yeah.
So from the action group's point of view, absolutely it should be in the S106 for the northern site. And reiterating the points you've made is that it should be they are two separate applications. And if for whatever reason the south failed but the north went ahead, we would not have no benefits of the proposed scheme.
Oh, that's fair enough. Mr. Gearing, have you got anything to say about that? Or either of you, really?
Yeah, we did discuss this with Network Rail previously, and because their focus was that the majority of users would be using Sittingbourne, that's why they factored that into the northern scheme, on the basis that if the southern scheme was granted, they'd both be coming forward. You'd have Sittingbourne and Teynham upgraded. I think we raised exactly the same question as the action group. We could take it away and see if there is an alternative scheme where you'd have a less amount of upgrades in Sittingbourne perhaps and same amount in Teynham if the north only came forward. But I'd have to discuss that with Network Rail and Mr. Dygan.
Well, the Teynham...
just because of the scale of the scheme.
Hold on a minute. So are you saying then, that there would not be any justification for it if just the northern scheme
So
came about?
I think the agreed position was that if the northern scheme only came forward, Network Rail was satisfied that the upgrades to Sittingbourne mitigated the impacts of the development. That's in the agreed statement of common ground.
So, is that right?
That formed the basis of our discussion, yes, around how the sustainable transport strategy would work. As I say, there are some cycle spaces of it at Teynham. It's not the same extent of the situation at Sittingbourne in terms of the use. Clearly, if there is obviously this is it's a complicated situation with regard to how the sites are sort of separated. If there was the opportunity for us to secure some funding towards Teynham as well as part of the northern site, then we'd obviously welcome that. But our focus at the moment was on Sittingbourne Station. So
in terms of the contribution, let's just look at how much it was again.
For the £100,000.
Just a minute. And, well, just before we discuss the principle of it, can you just explain how the £100,000 and what it's for and so forth, please.
So the £100,000 was derived from the same way that the Sittingbourne quote was, in terms of our preferred supplier giving a quote. Again, that would be index linked, and that would provide again some additional capacity to what's there at the moment, not to the same extent of Sittingbourne in all likelihood, and the facility would likely be smaller, just because there's less space available to put it. However, again, it would be a full shelter, lockable, with this sort of lighting and all that sort of stuff to make parking bikes there secure. At the moment, there's only hooped hoop cycle racks there at the moment where people just tie their bikes to, which is obviously not an ideal situation. So we would like to improve that where possible.
So, and there would be more of them, would there?
There would be. There wouldn't be a huge amount more because of the limitations in space, but there'd certainly be a sufficient number to cater for increased use.
Ma'am, we went to the site and I had Mr. Hatton actually identify where it would go, because at the moment there's some shift. We wanted to understand exactly where the stands would go.
Yeah.
At the moment there's a couple of Sheffield stands on the station platform itself, but that's not ideal. And also, if you go into the car park in front of the station, so what I can say is Mr. Hatton's thought through where it would go and how he would fit it in, and what else would need to be done from the footpath to this cycle parking area. So there has been some thought that goes into the cycle parking at Teynham, and then that feeds into the cost. But I take your point in terms of it being slightly illogical that you have Sittingbourne coming first with the northern application, given the proximity of Teynham. But Network Rail have looked at travel patterns, as it were, and they think that Sittingbourne is the more likely of the two to have the higher demand. And based on the advice from Network Rail, the council hasn't objected.
But so in the southern one, then in the southern scheme, there's no. I see. So they're split up, in other words. So if just the northern scheme went ahead, that would, doesn't really seem right, does it? That would bear the whole cost of the Sittingbourne upgrade for 1,000 however many houses, and if the whole lot for 8,400 houses, there wouldn't be anything extra for Sittingbourne, but there'd be a couple of more racks for Teynham.
Just on the Teynham scheme, it's I've got it in front of me here. It's a 2-tier cycle racks for 40 cycles.
Have we got it somewhere?
I've got the details here.
Yeah, but where can I find them?
We can share them.
Oh, you haven't got.
No, it's just in the correspondence I've had previously.
I see.
But it's for 40 cycles plus 10 open shelter cycles and 2 cargo bikes. So we didn't have the number, but I thought I'd just say it's not a couple, it's 40.
Right,
Point
so
being that I see your point.
So you can have 40. So at the moment there are 2 on the platform, and you're going to take those away and put 40 somewhere else. Yes,
So
outside.
Because you can use both sides of the Sheffield stand, you can get 4 bikes on it.
Right. Okay. No, that's so. You're going to have Sheffield stands for 40 bikes. Yes.
Not Sheffield stand. No, it's a secure, essentially cage with a secure arrangement that you see on a lot of stations of a similar scale. 2-tier, so stacked up over 2 levels for 40 bikes.
Okay.
It's kind of essentially a compound that's 4 meters deep and then varying in width. But we've got all the details of what informed the quotes. But your point you were saying was right. It feels like it's around the wrong way. I think you're kind of getting at.
Well, I think there should be both, really. I mean, fact is that the Teynham, I would have thought. I mean, obviously, people from the southern scheme would use Teynham, I expect. But they're less like. I mean, it's more likely that I would have thought that the northern, and it's quite a big scheme. I mean, it's I know we're talking about it as a smaller one, but I mean, it's still 1,200 or more houses, isn't it? I mean, it's not some sort of little, little whatever. It is a big scheme in its own right. So it and the sustainable transport strategy, I think, or at least when we were talking about it, Mr. Wild, who's listening, I think, you know, we talked a lot about, you know, where the people will get out onto, gosh, it's such a long time ago, the lane.
Road.
No, not
Road,
Lower Road. It
Station
goes
Road.
out of the other one. Sorry, I'm not.
Teynham.
No,
You've got Lower Road, you've got Station Road, and you've got Frognall Lane.
Frognall Lane. It goes out onto Frognall Lane, and then it goes up, and then it's going to be an improved way into the station. So we talked quite a lot about that, didn't we?
May I just add on that one? Just adding on that one bit, also if it goes ahead, the Northern only goes ahead, it's nice to complement and give facilities for the existing local population. So having the additional cycle racks in the station is not just also for the benefit of the new population, but also the existing.
It is indeed, but you have to be careful that the development can't expect to pay for existing shortcomings. So I'm sure that there would be benefit to local people, but we have to think primarily of what is needed to serve the development itself. Yeah.
Mum, if I can wade in.
Yeah, of course you can. Go on.
Sorry. So the 5 parishes agrees with the action group on this. And I think the question is, we've just presented some information here that we're not party to about the design. But this sounds like the description of it, quite a big asset. And I don't know where that sits on the platform. Because otherwise, are you taking out disabled bays in front of the train station?
I mean, this is about the sum of money that we pay to Network Rail. They would decide the design.
No, you're talking about room for 40 bikes.
Yes, but that's the Section 106 would transfer the money to Network Rail.
Yes, no, I know.
They
But
would
she was
then,
just asking where they would go, basically.
I know, but I don't think that's not
Well,
the
I
decision
suppose
that's made now. Is
No,
it?
but I mean, it is relevant if there's not space, I suppose.
Yeah.
That's the only thing. I mean, but presumably you've done some sort of assessment.
I mean, that's what Mr. Digan said. They've done some work on that.
I mean, we don't want to get too involved. I agree. We don't.
I think we've had a message from our transport consultant who was listening, and he said the reasoning behind the Sittingbourne logic is that most people would walk from the Teynham West to the Northern application scheme to the station. It's, the houses are in walking distance, whereas Sittingbourne's in cycling distance. So from a transport consultant's point of view, there is logic to the approach that Network Rail are taking as well. But I do understand your point as well that if people are cycling from the Teynham scheme, it would be better to have more facilities than that are currently there, which is obviously 2 Sheffield stands, which are on a platform which isn't really adequate.
I mean, they might walk if they're on the eastern end. But I mean, again, it's big development. It isn't just some sort of, 20 houses, is it? I mean, somebody who lives down the other end, I know it's all constant. I think it needs rethinking.
Should we take it away and come up with a better solution that you're happy with?
Yes. I mean, I'm certainly not happy with the way it's split up like this. Because you have to remember that they're both independent deeds. Right. All right, thank you. All right. Anything else you want to say about either of those facilities?
No, I think as I sort of said earlier, I think our feeling is that Sittingbourne would most likely be the most used station in comparison to Teynham. However, I completely accept that the facility, that shouldn't mean that the facilities at Teynham shouldn't be upgraded or that there won't be extra use. So we're happy to take that away and discuss that with the applicant.
I mean, having a station in quite close proximity to your site is a great, not many sites have that. So
No, we've got 2, so it's really good.
It's
So yes.
important, Okay, Mr. Hatton, it would be very helpful if you could I know it's not strictly Section 106, but could you just tell me what Network Rail's position is on the bridge, please?
Yes, thank you, ma'am. So our position on the bridge at the moment is that we don't have an objection in principle to the road bridge being built over the railway. Clearly, should consent be granted and the road bridge needs to be provided, then there are a number of processes and standards that would have to be achieved subsequently in agreements with Network Rail around land either side and sort of the standards used over the railway. And obviously that's any sort of agreement to that is subject to those issues being agreed after consent. But at the moment, our position from the planning perspective is that we don't have an objection in principle to the bridge.
Thank you. Right, Right, anybody got any questions on that? Miss Bonney?
I'm just wondering why Network Rail not signed up to the Section 106.
Okay. Might be a lawyer's point.
Yes, we wouldn't normally be a signatory unless it was directly affecting a station. But I accept there are times when we are signatories to it. So if it's felt necessary, then we could consider that. But yes, at the moment we haven't suggested a preference to be part of the 106.
I suppose Section 106 doesn't actually have any covenants in it, does it? Relating to the construction of the bridge? Are you saying you should do then? Right.
Yes, I think it should do. It's quite a significant crossing here, and it's part of the land assembly on the north. I do think it's critical that there is a compelling aspect from all parties who need to be to it, landowners and controllers with an interest in that land.
Who wants to? Yeah.
I'll perhaps start. I think we'll no doubt turn to the detailed drafting later on, but there is a very robust set of provisions in the Northern 106 dealing with delivery of the Northern Relief Road, and we certainly wouldn't expect Network Rail to need to be a party. There are covenants which require us to secure the land and deliver that road appropriately without the need for Network Rail to sign up to the 106 agreement.
Okay.
Yeah, so if I could just add to that point really. So road bridges are not necessarily common, but footbridges are on our network, and third-party developers have delivered those and funded us to deliver those on their behalf before, in which we've not been signatories to the 106 for those. That's because the issues over land and property and all that those sorts of issues are generally covered in our basic asset protection agreements or a basic services agreement, which we sign with any landowners and developer who's delivering the scheme, and they are part of that process that follows after consent is granted, and that's what allows bridges to be developed over the rail network. So that's why invariably we don't tend to be signatories to the 106.
Okay. Okay.
Mark,
Yes.
I believe that Network Rail think that the applicants own all of the site. They don't. They don't own the land north of the railway line, and they don't own the land south of the railway line. That is why I've raised it.
Okay, I mean, yeah, it's not really an issue that directly affects us. That's obviously for the applicant to deal with, and we're happy to discuss with them over the road bridge as and when that issue comes up.
Okay. Okay. Well, yeah, okay. Thank you. Right, Mr. Hatton, thank you very much. That's been very useful. Has anyone else got any questions or comments?
If Mr. Hatton could give us comments in relation to the trigger for the southern contribution, contribution for Network Rail on the southern application.
Oh, this is for Teynham Station, you mean? Sorry, yes, I should have asked. I assumed that was all going to be the upfront like the northern one, but... No,
sorry, I should have clarified that earlier. We feel because of the existing use there, we don't necessarily need that paying preoccupation. We're happy to agree a later occupation trigger for that. I think we worked out on the basis of sort of a equivalent of 1% of occupation, so perhaps 70 dwellings for that to be delivered.
Because you don't think it will be as used as...
Potentially not, no. And there's still the ability for people to still use that beyond its existing capacity compared to Sittingbourne, which is why we wouldn't be seeking a preoccupation trigger for Teynham.
Okay. Anybody? Yes, Mr.
I'd go back to the point of I still think in comparison to if you've got HS1 going from Sittingbourne and from Faversham, you've got the fast speed. It's 59 minutes to St Pancras, and from Teynham it's 1 hour and 6 minutes to Victoria. So the difference between the two services aren't that great. And I would counter-argue to say that I think that you've got a brilliant asset, albeit a slightly limited service from Teynham, and the proximity of the new development to that station would actively encourage people to use it from the new development.
I think we take away, and we'll speak to Mr. Dygan and Mr. Hatton and look to a revision that we'll provide back to you.
Thank you.
I think that's when not to the inquiry.
And finally, these applications aren't just about homes, they're about employment, and I think we're forgetting that some of this is about commuting to workplaces from employment spaces, and I do believe the North has some, and I think there's some wording in one of the documents, CD 4.18, that it considers that this will be essential in order to meet the pledges made by the applicant to deliver healthy, sustainable, inclusive development for members of the community, ensuring all residents, employees and visitors to this development benefit and convenient linkage to the surrounding amenities. Walking, wheeling and cycling are specifically mentioned there.
What are you looking at in the sustainable transport strategy or something else?
This is CD 4.18. I can find you the full reference later if you like.
Okay. Well,
And sorry, the longest property from the station is a mile away, so it is, you know, it's not just a short walk. You know, it's not a couple 100 yards around the corner.
okay. Anything else? No? All right, thank you very much. If you wanted to go, that's fine. But you're very welcome to stay.
I'll stay for a little bit.
You'll stay for a bit longer. Okay, that's fine. Thank you. Right. Now, what I suggest is that we start now with, shall we start with the northern site or the southern site? I don't really mind. But shall we start with the northern site? Let's do that. Right, okay. Now the way I've done it is just to basically work my way through the documents, picking up stuff that I think just needs a bit of explanation or, well, explanation really. And so if we go through, and then if there's something that you want to pick up before wherever I've got to, then I would suggest that you say so. I mean, my first one actually is, hold on page 21, and I know we've dealt with this before, and I can't remember what the answer is, so I'm going to ask it again. Could you just remind me what it's clause 24, what the Rivendell site is? Please.
It's a property, I believe, and it's the property that's a bungalow in Tong that is subject to an option agreement.
Is that the one that's going to be demolished? No.
This is
I think
We've got it on our plans for the...
so there's no demolition of relating to that property proposed.
So could you just remind me then...
I think it's parties, to help you out here, Mum, it's parties 4 on the front of your agreement.
Yes, I think...
Yeah, I agree, that's correct.
So
Essentially the Shires
it's party
is listed. Catherine, Shires, and then it follows through.
So I
the
just
other
wondered where the
panoramas.
property was, that was all. Well, we'll just, we've got the plans, haven't we, of the file with the ownership plans in it. Haven't we? Have you got those? I've got them in hard copy. So perhaps somebody could, oh, actually, I'll tell you what.
What's the CD reference for that? Has anyone got that
I've
handy?
actually no idea because I've got it in hard copy, sorry. Hang on, who's the name of the...
Is it ID 124? Yeah.
is it... So, yes, I know I've got... yes, thank you. Yeah, I've got this. Yeah, thank you. So which one is it then? Which... Number 3. I'm looking at the wrong... Oh no, not that one. Hold on. 3 obliques. Oh.
It's the land we walked through. Do you remember when we did our site walk from to get to the stream from the eastern side, between adjacent to the Stones. So the Stones farmland, which is 8, is to the west, and then to the east is the essentially it's Orchard and what's been referred to as the Tong Country Park.
Oh. Oh, there we are. Oh, yes. I've got it marked up here now. Righty-ho. Thank you. And so basically that clause then, just going back. So I don't, could someone just explain
I'll just try
what
and
clause is then?
try and explain. So in the front end of the Northern Agreements, we recite the proposed parties, and in the recitals we then set out, by reference to Schedule 1, the details of the interests held by the various parties. And I think part of the recital may have slipped out in this version, and actually I can't see a definition of the Rivendell site in this, which is perhaps why you've raised the query. So I think it's perhaps unintentionally slipped out. But in essence, the first owner, as defined, is G.H. Dean, and the first owner is interested in that title by virtue of being a beneficiary of an option agreement, and we've defined that particular land as the Rivendell site, and the benefit of that option was assigned to the promoter. And so the reason it is distinguished in this clause is to confirm that the first owner consents to its beneficial interest in that site being bound by the terms of the 106 agreement.
So they've actually bought that site then, have they? Dean?
Yes. No. Sorry, they have the option. Sorry, they have the option, but the option has been assigned to the promoter.
So they've got Deans have got an option on that land. Is that correct?
Yes.
Right. And this confirms that that land will be bound by the deed.
Yes.
Is that right?
Yes.
Okay. Thank you. So we ought to have, shouldn't we have a definition somewhere of what Rivendell is?
Yes, I think that will just go back into the recitals.
Okay.
We've had a bit of back and forth with Swale Borough Council on the recitals and the land interests, and I think as part of that discussion that has slipped out for some reason, but it should be defined clearly at the outset.
Right, okay, great, thank you. So moving on, if no one's got anything before that, to the schedule. And there we've got a whole lot of clauses about the back-child link, haven't we? So you have to help me here, because I thought, and I think we were told that we might need to sort of get up the Section 106 agreements for the land in question, which on the map is the yellow land, isn't it? And the yellow, the Tremport land, in other words, yes. And that land is in two bits, isn't it? There's a east-west and then a north-south, as far as I can see. Is that right? And the east-west... Now, I thought you said that the east-west link, which is necessary in order to give access to the Church Road site, that is part of the application. There's an application for reserve matters or something, and so that's being provided by the developer of that site, but there was a bit of a problem with KCC and whether or not they had actually or building it to the right specification or something. So, am I right there or not?
Hello, Madam. It's Matthew Stimson from Bevan, Britain.
Thank you.
I can probably talk to this and obviously hopefully summarise it accurately.
Yep.
If you have the plan, do you have the plan open?
Depends which one you mean.
Sorry, I'm working from a different set of documents, but the land ownership overlay, I think you referred to the yellow land.
Yeah, I think I've got one that shows it, which I think's okay. Yes.
Yes, that's very small on my version.
Mine's a blown up version of that. Yep.
So the yellow land you see has a corner to it, a right angle.
Yep.
And so there's a east-west section at the top of the plan.
Yes.
And then so that is covered by one agreement.
Is that the Eurolink agreement?
Yes. Which we will, I'm sure, turn to shortly.
Yeah.
And is the section of the road that is the subject of the reserve matters application currently that provides access to the Church Lane development.
Yeah. Church Road,
sorry.
and that will be built by the developer of the Church Road. Or built by Kent County Council with the money from the Church Road people, will it?
It, I believe, if it progresses under that scheme, would be built by the developer pursuant to their reserve matters.
Ma'am, there's a reserve matters application from Tremport in relation to that portion of access to the site. And we're obviously, as part of the application, it's being consulted with Kent County Council Highways. I think one of the debates is whether it's at the right level and adequate in terms of being that forearm for the Northern Relief Road. But it's still a live application. It's not been determined yet. Is Alan here? But just pass over to Alan Millard, who's the Kent County Council Highways Officer, and he might be able to give us an update.
Yep. Yeah.
Yes, thank you, Ma'am. Yes, it's a live application at the moment, so we're still working through the details with the applicant on that proposal to ensure that the details that are submitted are going to be compatible with the future alignment of the Northern Relief Road. So that's still being worked on at the moment. So it's a live application.
But nevertheless, for that section, the Church Tremport, is Tremport the actual Church Road developer then?
Yes, that's correct.
At the moment, or I don't know whether they're a promoter and they'll get a house builder.
No, you're right. There could well be a house builder that comes along and works.
Yeah, but they own the land anyway, and they're. But
yes, and the reserve, the road reserve matters is by Tremport, not from a house builder. But the homes, you're correct. They could well be partnering with a house builder.
Right, so it's not unreasonable to say then that that section of road which is required to unlock the Church Road development would be constructed.
And it's quite difficult because there's a live application at the moment.
Well, I
and
mean, even but permission's been granted for the Church Road development, presumably with an access to it, hasn't it?
Ellen, can I pass that to you in terms of the details of access that were approved and what weren't approved?
Okay.
The application with Church Road was an outline, so it had parameter plans.
Sorry, it had
parameter plans as part of it, but it hasn't fixed the alignment of the road or the details for that. So these are the areas that still need determination.
Yes, but there's a legal agreement, as far as I'm aware, isn't there? The Eurolink agreement to require is that connected to that application, the legal agreement?
That's a separate. Perhaps talk through the 3 legal agreements.
Oh yes, of course. Yes, I think yeah. Okay. Well, let's talk about the agreement, the Church Road agreement, which is that. But was that access completely reserved?
Access wasn't reserved, but that said, the level of detail that was provided was limited to like parameter plans, and conditions were imposed on the consent to require further detail to come forward, and that's what's coming forward at the moment in the reserved matters application.
Okay. But nevertheless, if access wasn't reserved, it must show it from presumably that roundabout at the that we.
It's Swale Way.
Yeah.
Yep.
Along that corridor, it couldn't go anywhere else, could it?
Yeah, no, it can't go
Along
anywhere
that
else.
corridor, and then into the site.
Yes, that's correct. Yep.
And that site can't go ahead, I would imagine, until it's got some way into it.
Yes.
Presumably it's not allowed off Church Road, I wouldn't think, would it?
No. There's a debate about that, but I'll let Mr Mallard explain the Church Road element and access from it. So yes, you're right. To get into the Church Road scheme, you come in off Swale Way, and it's that left to right, east to west, the top linkage of what would be the Northern Relief Road, and it then carries on into the Church Road site. Alan, can I get you to describe some of the challenges that we're having in terms of levels at the moment with the live application?
Yep. So the Church Road application, they're required to provide a 7.3 metre wide distributor road standard carriageway into the site from the roundabout on Swale Way. So that's correct. It's the access is taken from there. They do have a limited number of dwellings that can be served from Church Road. I think it's 5 or 6, which is in phase 3 of the development. But phase 3 is part of the site that's safeguarded for potential routes for the Northern Relief Road. So they wouldn't be able to build out that part.
That's the south to the south. Well, let's just deal with that separately.
Yeah.
Yes. Okay. So most of it's going from Swale Way, isn't it?
That's right. Yes.
Yes.
So at the moment we're looking at the detail of the road to see whether it's going to be compatible with Northern Relief Road. The challenge is obviously with the Northern Relief Road, it's got to rise from where the roundabout is proposed to climb over Lomas Road and the railway line. So what we're looking at the moment and trying to find clarification on the details for the levels through there to make sure that the road can climb over there. We've got the sufficient gradient over the distance between the roundabout.
Right. Okay. So I mean, presumably the Church Road legal agreement indicated that that stretch of road would have to be, as you say, to the standards of the distributor road, and if it's not, and you've got the details, you won't approve it.
We won't approve it, no.
So,
It's not just the dimensions, ma'am, but the levels
well,
are
the levels,
important.
yeah, we saw, didn't we? But I mean, there's no other option for them if they want to get access into their site, is there?
No, it's just making sure that, so what's proposed at the moment isn't necessarily at the level that we would want it to
No.
be in order to be compatible with the Northern Relief Road indicative design. But it's a live application. We are often faced with applications where things are proposed that don't quite align with what the council wants, and that's part of development management, is to get things back on track.
Exactly, and I'm sure you will, Mr. Digan.
The Church Road 106 agreement includes a restriction on their occupying their development until the highway works are constructed, which includes that section.
Yeah, I mean, just, you know, from the county council's point of view, we'll stand our ground until such time as the road is the appropriate standard.
Yeah.
So you can work on the assumption that it will have to be to that standard. I don't in any way diminish the fact that it will be. It might be a struggle to get them there, but they're not going to have any other road other than the right road.
No. So the only reason I'm asking all these things is just to, you know, obviously we've got, and we've spent a lot of time in the inquiry talking about ownerships and so on and so forth, but it seems as if that section of road up to the east-west bit of the Tremport land, we can be reasonably satisfied. I know things are never simple, but that section of road won't run into problems of delivery or ownership, because it will be there and provided by the Tremport developer.
So it's safeguarded. So yes, you're right. There would still need to be some sort of commercial arrangement between the Highsted applicant and the Tremport applicant, and the Tremport do own that land. But
well, presumably it's going to be
help? Yeah, I think this section is the agricultural land value. Is that right? This section. So those are very legitimate questions for the next bits.
Yes.
But on this bit,
Yeah.
luckily the agreement actually identifies the value,
Yeah.
and so yes, commercial, but it'll be agriculture. And I'm sure people can have an argument about what a field of corn is worth, but the bottom line is, you know, you're only talking 10,000-12,000 pounds an acre.
But I can't really see why our applicant would need to purchase that section of land, because that will be an adopted highway, won't it?
Exactly right.
So I can't really see that there's any sort of issue with that bit.
We don't think there is.
No. So I think the issue relates to the area north-south of the well, when it goes basically southwards, isn't it? And to go over the railway, yes?
I think from our side, we obviously need to make sure it's retained within the Section 106 in case that scheme didn't come forward. So, you know, we need to have the ability to deliver the east-west section if the other, you know, everything we just discussed didn't happen.
Of course it has to be in there, but, you know, you have to use one's, you know, you have to think of reasonable, what's reasonable to assume. And I wouldn't say that anyone's going to say it's not unreasonable to assume that that bit of road will be developed. Obviously, if it's not, then it has to be dealt with. But yeah.
Madam, is it worth having a line in the S106? Our colleagues here have talked about the difference in height. There may be substantial costs associated with making sure the road is at the correct height. And it's just making sure whom would pay for that work.
Well, you mean as it goes up to the roundabout? The roundabout?
From the bit when the road, yes, from the roundabout from Swaleway that comes, the bit that goes straight down south. We understand it's about 6 metres difference. Well, if that turned out that the road had got to be, for some reason, got to be reconfigured, or the height has got to be adjusted, whom pays for that?
Well, I think from what Mr. Wild said when we were on the site visit, the road would start to climb from the roundabout up. That's what I understood anyway. That the roundabout wouldn't necessarily have to be raised, it would be the road. I don't know.
I think this is what Mr. Millard was referring to, of making sure that the vertical alignment in the Trentport Reserve Matters application is to the satisfaction of KCC, so that it isn't set at a level that means the rest of the Northern Relief Road wouldn't work, essentially. So it's making sure that it's fit for purpose. The east-west element of it that is approved and delivered, if it's delivered by Trentport, is fit for purpose to form part of that Northern Relief Road. And that control is not just through the Reserve Matters application, but the Section 106 agreement as well.
Yeah, the Section 106 agreement basically says, as far as I'm aware, that it has to be to a standard of that's for that bit of the Northern Relief Road. So I think up to the roundabout, it probably is covered.
Yes.
And obviously, if things go completely awry, then obviously it has to be dealt with. But all right, thank you. So you've explained that. That's helpful. So really, the Eurolink agreement then, because we're told there's a Eurolink agreement and a Church Road agreement. The Eurolink, I'm not quite sure. Could you just explain the two? The difference between the two.
I might be able to assist on this.
Yes,
again,
thank
Mum,
you.
if I may.
Thank you.
Yes, so this is where it gets slightly confusing.
Yes.
So the Eurolinks agreement is the... sorry, I'll get the right date. Yes, it's the 20th of December 2013 agreement.
It's an old one, isn't it?
That's it is. And that's the agreement that safeguards that stretch of road that we've just been looking at.
Right.
So it's if the Church Road development didn't come forward and didn't deliver that stretch of the road, it's under the Eurolinks agreement that Kent County Council would have to exercise its ability to acquire the land.
Okay, and then the Church Road agreement.
Yes.
Then.
So the Church Road agreement has two relevant schedules in it. One which deals with the construction of that part of road by the Church Road developer.
Yeah.
And they're the obligations that we've just been talking about, which require it to be constructed to the distributor road standard and not to prejudice the delivery of the wider link road. But as far as safeguarding is concerned,
Yeah.
The agreement itself is not 100% clear, which we will come to when we look at in detail. However, our best interpretation is that it safeguards the land south, so the north-south stretch.
Right, I see. Okay, and that's also has that not got a clause in it that they can't build houses on that bit?
Yes, it does.
Would it be a good point to look at it, do you think? Or
It might be to explain the...
okay, so could we have the CD number then, please?
Madam, I was just going to explain as well, there are planning,
Mr. Bashforth,
there are planning conditions relating to that permission as well as 106 obligations as well. So as well as looking at the obligation, which I'm sure we're going to do, it's
Yeah, we're about to do that.
it's probably also worth looking at ID 129, because remember there was that note that the applicants and the county put together, I think it was in May, which explained the planning history, the planning permissions and the obligations as well. So I think you have to read
Do you
things.
think we could deal with the whole thing without looking at the obligations then, do you think, from that note?
We could
or-
do. I mean, this takes them. This note actually takes sort of extracts from the 106. But I mean, if we want to go to the original 106, that's fine.
I
as
don't
well.
mind, whatever you think's best.
I think both, ma'am, and then you can understand why the conditions are important as well.
Right, okay. I told you this would all take a long time, didn't I? I know. It's quite complicated. I think it's necessary to make... I know we've been over this a bit before, but not in this context. All right, let's go to the section 106. Could you give me the CD number, please?
I believe it's an inquiry document.
Yes,
Is it?
It's
section 106, yep.
Is it 100.29.2.1?
100...
29.2.1.
Right, let's...
Yes.
What's going on here? Sorry. Just a sec. My computer's... Right. Let's get both those documents up, shall we? Right, the first one, 29. And then, oh, hold on. So 29 is the note, isn't it? So which is the legal agreement is 29.
29.1.2, I believe.
2.1.
2.1. Right, should we look at the legal agreement first? Does someone want to sort of talk through it for me then, please? Or just the relevant bits? Yes?
Yes, I can do that.
Simpson, yep.
So, looking at that agreement, they're usefully next to each other, but Schedule 7, we'll just start there very briefly, which is on page 56 of the document, of the agreement.
Anybody got the PDF? Schedule 7.
Page 56 in the PDF.
Oh, good. Yeah, okay. Okey-dokes.
Yes. So I just pause here just because this is the highway works schedule. Should you want to look at it, and this is, as we said, these are the obligations that would require the developer to build the east-west alignment.
Okey-dokes. Thank you.
So, just actually on the next page is the start of Schedule 8,
Yeah. So,
which is the land safeguarding and relief road.
yeah.
So, starting with paragraph 2,
Yeah.
which is the safeguarded land, and we have there reference to the safeguarded land as defined, and there is a definition of that. So this is where one of the complications arises. Unfortunately, as always, there's a bit of flitting around in the document, but we have it.
Definitions beforehand, presumably somewhere, is it?
Yeah, so the definition is just above in
yeah.
in paragraph 1.1, which is safeguarded land.
On the plan.
Yes, well, it says means that part of the site shown edged blue on Plan 1.
Thank Where's plan 1?
Well, the definitions, the definitions of the plans are at the front end of the agreement. I don't know that we necessarily need to turn there, but there are 2 plans. There is plan and plan 2. So there isn't actually a plan 1. Now, if we were to assume that plan were plan 1,
Right.
plan 1 does not show a safeguarded area edge blue. However, plan 2 does.
Right. This is why you need to go through these documents very carefully.
So,
The inspector did not go through it very carefully.
so plan 2, I believe, is right at the end of the 2 plans. In fact, we can probably turn to those. They are.
Sorry, so where am I going?
Yes. So about 2 or 3 pages on from Schedule 8. So at the end of basically of the agreement that you're looking at.
Oh, yes.
PDF 61.
Oh, yes. Okay, thank you.
So you've got an Appendix 1 there which says plan and plan 2. And they're in that order. So plan 1, plan simply shows the application site edge red.
There's a blue bit on it, doesn't it?
It does have a blue bit on it.
Which is unowned land.
Which is what?
Unowned land. They've identified that within that site there's a little bit of unowned land, unregistered land.
So we're assuming then it's plan written on. My goodness.
Yeah. So the final plan. There, yes. So you can see the familiar sort of dogleg of the road, and and there is some very small writing. You might be able to zoom in, but you've got a key, a legend on the right hand side of the plan, and there's at the bottom of that there's a sort of hashed, a dotted line, and next to that it says safeguarded land. And so on the plan itself you have a dotted, let's call it blue for the sake of argument, dotted blue outline of an area of land which corresponds to the sort of safeguarded area within the local plan.
So that actually goes up to the roundabout.
It does.
Righty ho. So if we go back, are we going back then to the schedule now?
Yes.
Okay. Hang on a minute.
57.
It's back to 30. What's that bit of land? Beyond the blue. It doesn't matter. So the safeguarded land is all that land in the dotted line then?
Yes.
And the blue land actually relates to where they were going to build these houses, is that right?
Correct.
Four. Right.
And because there are options for the Northern Relief Road, it could travel north of the railway line, or it could, as is proposed, travel directly south, and that would affect the blue area, which is a phase of development that can't come forward for 10 years. Or if the decision was made that the Northern Relief Road travelled to the north of the railway line, you can see that there's sort of like a purple area that's approved for housing that would not be able to be built for 10 years in case that was the route. So that's why it's that triangular shape, the safeguarded area. But the Highsted applicant is proposing to go straight south through what would be the blue area, which I think is phase 4. So phases 3 and 4 can't come forward for 10 years. And if you think about it practically, if it is the case that the Highsted scheme, which goes directly south through that blue area, then the blue area clearly can't be built upon. But it might be that in the fullness of time, Tremport can build out the purple area, phase 3.
So how many years is it, did you say?
10 years. And it was consented in 2023, so we've still got 9 years to go, 8 or 9 years to go.
So who? Oh, it doesn't. I suppose that doesn't really matter. That's fine. Okay. Lots of questions I would have, but they're not really relevant, so we won't go into those. So let's go back to the schedule then. Now we know where it is. This is 8. Right. Okay. Okay, can you carry on with what you were saying then?
Yes, I can carry on. So, in paragraph 2, we have the restriction on the carrying out any development on the safeguarded land for the safeguarding period, which we've just heard is 10 years from the date of the agreement.
Yeah.
And then you have various provisions in there for when the safeguarding restriction might cease to apply, which I think essentially we can say no longer apply because they're related to this was in anticipation of the local plan coming forward,
right?
And it essentially says if the safeguarding falls out of the local plan,
yes,
then the safeguarding under the agreement also falls away. So I think for present purposes we can disregard those clauses.
Right.
There is then in paragraph 3 potential to review the safeguarding obligations, which essentially again if they're considered, if all the parties consider that they're no longer required, they can fall away. There's also the ability for the parties to agree to extend the safeguarding period, if necessary, to be where a local plan is adopted which requires extended safeguarding, or if there's a planning permission in place for the construction of the road. Just pausing there, this is paragraph 3.2 of that schedule.
Yeah.
I'd stress that it is for such period. This is the extension, such period as is agreed between the parties to be compliant with such local plan and or planning permission. So it would require agreement between the parties.
And that's between the council and Tremport.
Essentially, yes.
Well, presumably there's a dispute procedure. If one doesn't agree.
There is a dispute resolution procedure in the agreement, yes.
But anyway, so then we go into the controls, don't we?
Yes. So obviously, yes, 4.1 is important. Owner covenants with the Borough Council and the County Council not to use the safeguarded land for any purpose or in any manner that would make the safeguarded land unusable or that is incompatible with the use of the safeguarded land for the construction of the proposed SNRR and purposes ancillary thereto.
Rightio.
And then we have a number of subsidiary controls over the use of that land, which are obviously quite important. Not to use it for drainage, not to alter the levels that would affect the SNRR, not to remove any materials. So,
can I ask a question, Mum?
Of course.
What about services? because there's existing services that run down that land.
Well, there's a control on not installing any services in or under the land, but the agreement doesn't provide for removal of services from the land.
I mean, that would have to be dealt with presumably if the new road were to be built.
Yeah.
That's very helpful. Anything else to say about that?
Well, on that, do you want me to go on to the acquisition provisions?
Oh yes, actually yes, of course.
So this is, I suppose, the important bit, and so we have at 4.3 that's a control. This is the owner covenanting not to dispose of the land or create any interest in it, except in favour of the county council.
Yeah.
Which is quite important. And then paragraph 6 is the next important one, which is the last one there.
Yeah.
And this is all we have in relation to the county council actually being able to acquire the land.
Right.
And so, if I may, I'll just read it. It's very brief. At any time, and from time to time after the adoption of the local plan in a form that includes the allocation of some or all of the safeguarded land for the proposed SNRR, or the grant of planning permission, which in this schedule means the planning permission for the SNRR, the county council may serve the confirmation notice on the owner.
Right.
So we have to then look at the definition of confirmation notice, which is at the start of this schedule.
Ma'am, just before we move on, if I just come back to 4.2, and this is just to respond to Councillor Bonney's concern in terms of services.
All right, yeah.
So it does start without, and Matt, if you can confirm, without prejudice to the generality of paragraph 4.1, so it's not a closed list. It could include services, for example.
Yeah, thank you. That's useful because that's the Southern Water trunk main that runs along there.
Yes, thank you. So we were just looking at the very start of Schedule 8 and the definitions, and the first definition there is confirmation notice. And that means a written notice served on the owner by the county council confirming that the safeguarded land is required for the construction of the proposed SNRR, to include a plan identifying how much of the safeguarded land it considers is required for the construction of the proposed SNRR, and confirmation as to whether the county council require transfer or otherwise of the safeguarded land or such part identified. So technically, the county council can serve a confirmation notice saying that they require transfer, but what isn't in the agreement is a corresponding obligation on the owner to actually transfer the land to KCC, and there's no provision for determination or specification of the price of the land.
So they can say, can county council can say, serve this notice and say they require the land for the building of the Northern Relief Road.
Yes.
But Tremport don't have to. Well, presumably if they compulsory purchase it, they'd have to, wouldn't they?
Well, yes, compulsory purchase being obviously a separate.
So this is talking about agreed transfer of the land.
Exactly.
So would that? I see. So that would be agreed transfer of the land for a price. Is that right?
Yeah. If I can just add, even though it's not expressly set out in that way, reading the agreement as a whole, It is clear what's intended as part of this agreement. It's safeguarding the land for the purpose of the transfer. So it's a technicality, but we don't actually see this as an issue in practice. Just wanted to make that clear.
So you think that they would have, you know, if Kent County Council served that notice, then they would have to comply, do you?
Yes, I mean, if they disputed it from a litigation point of view, it would be really hard for them to argue that that's not the intention of the agreement.
I see. But that doesn't say anything about what they're going to ask for the land.
No, the price is absent. There's nothing in there about price.
Mr. Young, you said that in relation to the agreement on the northern bit of the land, I think it was the Eurolink agreement, that it actually stated agricultural use, didn't you?
Yeah, there's two Tremport agreements, and actually it's the first one. So in our plan, the agricultural land is referred to in this part. In this agreement,
right.
And you're talking about this one, obviously.
Yeah.
That set the price at agricultural land value in the blue, in the section 106 with the blue site. That land was then actually required to be built out. So arguably the agricultural land value is extinguished because the land, they had to build it. They have to do that, but at least it did set a price and an expectation. And of course, when Tremport came to sign the section 106 for this one, you know, they knew that the most they'd get was agricultural land value. So for that section of road, they agreed, I'll be corrected if I'm wrong, but they agreed to actually provide the road for which obviously they needed to get access into their site. None of that, no inference about price relates to this.
I see. Okay.
So you asked about CPO powers, obviously. I defer to greater knowledge, as ever. But the CPO process, as has been said by Mr. Stimpson, is a separate process. The starting point would obviously be to enter into discussions and negotiations over the land with Tremport. But if that couldn't be resolved and you know, obviously we're mindful of the period of time that's left, then it would be necessary to instigate CPO powers. And again, the price would be the market price of the value of that land in all of the relevant context.
But it would be the market price as safeguarded land, not the market price as built.
I don't want to go beyond market price, and we're not in a CPO inquiry. It'll be the value of that land as viewed by the owner, and it will be obviously ultimately subject to the lands tribunal if there's a dispute over that. But I defer to those with greater knowledge.
Is that right, Mr. Pereira?
I think Mr. Young's appropriately cautious on saying more than he's saying, because the general premise the general premise is that it's market value, but then there are all sorts of statutory assumptions that apply where it's a compulsory purchase, and lawyers tend to argue about what the effect of those assumptions are. I mean, classically, of course, the landowner will say that the assumptions increase value, and the acquiring authority will say that the assumptions decrease value. And the reason that's complicated is because the statute requires certain things to be cancelled or assumed not to be, and it also requires then, or can require, questions about what assumptions might be made in the space that's left. And so it's not straightforward, and I don't think, without thought, I don't think it would be prudent for anyone to kind of claim to be able to say to you definitively what the basis of market value would be. That would
Okay.
if the parties aren't cooperative, that would be a highly contentious issue. I think.
Ms. Bonny, do you want to speak?
Thank you. Yeah, I mean, clearly there's concern here because this is no slam dunk on land assembly and could end up in litigation. I can say that as a third party or Rule 6 party. But we've just seen here, there's also a parcel of unregistered land. What if they come out the woodwork? Presumably this covers it. And we know that it's got planning for 65 houses on that chunk of land as well, just to draw you back to the planning as well as the ownership issue.
Yeah, but they can't do anything with that.
No, of course not.
It's safeguarded.
It's safeguarded, but yes.
Okay, thank you.
Can I just add one thing? I think one thing that probably should be said to assist you is that obviously the compulsory purchase process exists because parties can't always agree on price.
Yeah, well, that's what I rather thought.
Yeah,
when
and
I've done CPOs.
Yeah, exactly, and so the whole purpose of it is to ensure that, depending on the parties' attitudes, land can be assembled even when there isn't agreement on price. So there are timing issues, and there are issues around decision making that needs to be taken by relevant authorities. And as the inquiry's heard, there'll be issues on how that might affect the money that needs to be contributed to land assembly, but the purpose of the regime is to overcome points like that.
I mean, from my experience, I have to say that people usually prefer to try and get what they can out of negotiation, because once they get into the compulsory purchase regime, it's a bit of an unknown, isn't it? So, you know. Anyway, we can't say, can we? We don't know. So. Okay, is it time for a break? I think it might be. Have we, can I just see if there's anything else on this? It would be nice just to finish the back child thingy, wouldn't it?
The only thing is the conditions, perhaps. And again,
Oh,
I can give you a reference for those because they largely replicate what's in the Section 106 obligations.
Okay, is it in that note?
It is. All the source of it is from that appeal decision, though. So.
Well, if you just say...
yeah,
just
so
tell me...
the appeal decision's in CD 30.2.
Yeah.
And then the relevant conditions are condition 6, which is on PDF page 9, and condition 7, which goes over the page to PDF page 10.
Okay, that's great, thank you.
But I mean, again, it just safeguards the land, and just as we've been discussing, relevant to phase 3 and 4, so that purple and the blue land.
Presumably it reflects what's in the legal agreement.
Thankfully, yes.
Right, okay. I'm sure Mr. Major didn't think that his decision would be so carefully scrutinized. Okay, jolly good. Just have a quick look, sorry. So that deals with that. D, control is something I was just wondering. Yes, I wasn't quite sure I understood under the what's meaning by control. Could you just explain what? No, I can understand A and B. I'm not quite sure on C and D. Oh, sorry. Control. It's the next. It's on page 29. It's definitions. Oh, we're back in Schedule 12 now of our agreement.
Yeah.
We've left the.
I could perhaps talk to that, madam.
Yes.
So the drafting envisages that either the owner and or promoter could acquire the land necessary for delivery of the Northern Relief Road.
Yeah.
But it also envisages that the county council could do so using its powers under these 106s that we have just discussed. And so control acknowledges those different eventualities, and as an alternative at Limb D, it anticipates that there could be an alternative which is securing grant of all necessary rights rather than necessarily the outright transfer of the land. It's just a fallback option to cover all potential means of securing requisite control to ensure that the road can be delivered on that land.
So C would be if the county council CPO'd it, would it?
Or were to use the powers in the 106 agreements that Mr Simpson's just described to acquire it by agreement, say with Tremport for an agreed price.
Okay. So would it be KCC rather than the promoter landowner actually negotiating with Tremport? Would it be the county council then that would be doing that?
It might well, yes. And under those agreements that we've looked at, it obviously is only the county council that can enter into those discussions formally. It doesn't, you know, as all things are possible, the applicants in this case could enter into discussions directly with those landowners and reach an agreement. But as it stands, under the agreements that we've just looked at, the power to serve notices sits with Kent County Council.
Just on that.
Oh yeah.
Without descending into all the CPA guidance, the acquiring authority, which would be Kent County Council, would have to enter into discussions and be able to demonstrate they've conducted those discussions.
Yeah.
And there's certain expectations around that, about what those discussions look like and how long they take for. There's nothing wrong with the developer doing it as well, but we're the ones who have to evidence it if we are to acquire the land.
Yes.
The real issue is, what is the land worth? Because the negotiations will proceed in whatever they wish they were, but the provision in the section 106 refers to the cost of the CPO. That's effectively the procedure for doing it all and the inquiry and so on, but also the compensation.
Yeah.
So the CPO, if it's to proceed, will only do so if Kent County Council is satisfied that they know what the compensation payable is. They're not going to just CPO the land and then be suddenly told it's worth this.
Well, presumably that will have to be dealt with by if it's not agreed. Well, it would have to be dealt with by the Lands Tribunal.
But, yes, which
and
would
paid
come
for by the developer.
Yeah, absolutely. But that issue of the Lands Tribunal comes after the CPO. So you acquire the land, and then the Lands Tribunal is if you can't resolve it. And so before you make the CPO, you want to have a pretty good idea of what you're in for, and also then you'll need the indemnity from the developer as to covering the compensation that Tremport then seek.
So when does it go to the Lands Tribunal if you can't agree? Yeah. So you wouldn't make the CPO. So if it went to the Lands Tribunal, you wouldn't make the CPO until.
No, the CPO comes first. Lands Tribunal comes thereafter if you can't agree a sum.
But Kent County Council would obviously need to, and they'd obviously seek legal advice from somebody who's expert in that area about. Not in this case, I don't think. They would need to have a pretty clear idea, and no doubt seek legal advice about what the compensation was likely to be, and then obviously the developer would need to indemnify against that.
They'd also seek valuation advice as well, as would we. Everyone would go into it with their eyes open There's no certainty over what the final valuation is going to be, but you've got, as Mr Young says rightly, everybody's got an idea. And then ultimately, if it can't be resolved through negotiation, then post-CPO, you would ultimately end up in the Lands Tribunal as the fallback, assuming that you can't agree anything.
You'd have the negotiation first, though, wouldn't you?
Oh, yeah. No, so negotiation goes on for a number of months or years. Assuming negotiations fail, CPO is the next step. And after CPO, assuming that you can't negotiate a sum, Lands Tribunal is the fallback.
So if the negotiations fail, you wouldn't really know what you're in for until it goes to the Lands Tribunal, would you?
You wouldn't know for sure, but obviously there's both expert lawyers and valuers.
You'd know the highest level, wouldn't you?
You'd know a range, and you'd have valuers advising you, CPO valuers, and you'd have CPO lawyers. There'd be a whole cast of characters who'd be giving you what your likely range is, and that would be necessary to inform an effective negotiation to avoid CPO in the first place. And you've got to show the inspector or whoever that that's what you've done.
Yeah.
So Mr Young's right, there'd be a whole bank of information on likely values, but you wouldn't know for sure until you strike a deal or until the Lands Tribunal tells you what it's worth in the end.
You go to expert surveyors who are specialists in CPO, and then you would seek their advice. And as, if I'm so learned from Mr Pereira says, you have to deal with all the assumptions that are in the statutes. But, we're talking years for this process. What you can do, and what is encouraged, is that you are going down the CPA route, and, we have got a time frame here it's all got to be done and dusted in the time frame. And I think, so we said 8 years now. You can negotiate whilst also pursuing the CPO. So you can do, in fact, I think you're required to do it simultaneously under the guidance.
Yeah. Yes, it's all coming back to me now. Right, okay, great. Thank you. So that's that done.
Could I ask, through you, for the wider room, what are the time limits for progressing a CPO? I don't know.
What are the what, sorry?
How long do they take?
Ooh.
That is a how long is a piece of string question. I think it can be anything from, it can be months, but it can be years. It very much depends on a number of variables that we don't really know enough.
Less than 8 years, though.
Less than 8 years.
But I mean, there is the provision in there to extend, isn't there? If
that's if the CPO is made. There's a bit of a process to get to there. So
anyway, we're probably getting a bit beyond what we need to know actually in this. Right, sorry, we ought to have a break. Yes,
sorry. Just thinking about this as a community here.
Yeah.
Obviously, there's a desire from KCC for the road. What this agreement in its drafting, if there is direct negotiations from the applicant with other landowners on other sites, and clearly KCC might be asked to use their CPO powers where those break down. I suppose in the long term, if that road truly is more than an aspiration and deliverable, is if this does not proceed for any reason, this application doesn't proceed,
right,
in allowing the applicant to proceed with negotiations, at what point is there the undertaking with KCC on those discussions so that they don't fetter the ability of KCC in the future to deliver the road should this not proceed? So could they go off and offer them, a vast sum of money, and the people up the north holding out, but actually in the long term it undermines KCC's ability to deliver the road because this application ultimately falls away, but it impacts the deliverability of other aspects of this deal. What we've found is this is a variable number, quite substantial possibly.
I can't see how KCC would be. I don't understand the hypothesis, because in the end, KCC have their own CPO and delivery powers, and there's nothing we could.
Are you saying that the applicants might go and start negotiation for the decision? Is that what you're worried about? Well, I doubt whether they'd commit to a huge amount of money without knowing whether they've got planning permission, though, would they?
No.
No, but if the cost of this is extensive,
of the whole
of the acquisition, it undermines effectively the viability of the rest of the Section 106 items that we're going to be discussing in the future. And what we don't want to find is, because there's been, and we know that the applicant doesn't have experience in this, but I'm sure we'll be hiring experts. But what this could do is cause chaos for the delivery of the rest of the Section 106.
Well, perhaps
Well,
then
that's
it's
what the whole
that's a
point
question
of what
to look
Mr.
into.
Young was worried about, I think.
Yeah. Well,
So, I mean, we've done, you know,
we've
heard all
sort
the
of
evidence,
canvassed all
haven't
of that, I mean, to an extent, and then I think the only thing that we haven't really done yet, because we've not had the 106 sessions proper, as in that we're doing now, is to actually go through what the triggers are and to work out what can happen when, what can't happen when, and all
Yeah,
of that.
we'll get in there.
I know, but that's the answer really, other than the
Yes,
evidence
yeah.
that we've had for the last month.
Yeah, I mean, it all goes to the argument, really, that it was made in the evidence, isn't it, about the cost and whether it impacts on other obligations.
I think it's the evidence that Mr. Young's witnesses were making and that Mrs. Dickinson was talking about, etc.
Yeah.
I mean, we the simple position is, and what
We don't want to go
establish-
over that again.
What we establish, what we establish
We're going to get anywhere,
is that we don't know the answer. That's the point. So it's not that anybody is suggesting a figure. We
don't know.
We just don't know. That's the point.
I think everyone agrees that.
We obviously all agree that.
Now, we haven't, the legal agreement I'm going to break, but just so you know where I'm going, the legal agreement doesn't actually mention anything about the council's land, does it? Should it? So can I leave that one with you?
Do you,
I'd like to leave that one.
you want to leave that? Okay.
And I'm going to go and have a cup of coffee. And then we'll be back in 20 minutes. So it's, let's say, 20 to 12. Thank you very much. inquiry to resume. We're not getting on very quickly, are we really? Probably my fault, but anyway. So I think I'm going to break the habit of a lifetime and suggest that we maybe have a shorter lunch break. I know, and don't look at it as a precedent.
I think.
But I've got so many of you in the room that we really do need to crack on, don't we? Get as much as we can done, and we're only part way through the northern one at the moment. So if it's all right with everybody, if just this once, we'll have half an hour. All right? And we will obviously have afternoon break as well. So is that okay? Okay. Right, so I mentioned about we've got no provision at all relating to the bit of land which is at the moment, but not owned, is it owned by whoever the developer of Stones Farm was, can't remember now, but is shortly to be owned by the council as I understand it. Should there not be some sort of provisions in there?
We don't think that there needs to be. The definition of backchild link delivery land encompasses all of the land required for delivery of the link road, and so the provisions requiring that land to be acquired or secured for delivery of that road applies. It's only that there is, in the case of the Stones Farm land, no associated 106 agreement that would directly enable that land to be called for, hence we don't have direct reference to it in the drafting, but it is covered by the obligations to acquire that land.
But why? I don't really understand why it's. I mean, what happens? You know, we've had various scenarios, haven't we? Put forward by Kent County Council in particular, that maybe the council wouldn't be very happy to part with the land, and it might have to be CPO'd and all the rest of it. So, in a way, it's sort of similar to the Tremport land, isn't it, really?
It would still be covered by the paragraph which provides for Kent County Council to go down this compulsory purchase route if required. It's just that it's not specifically identified, because unlike the others, there is not a specific process for using rights in 106 agreements to acquire it. So the backchild link delivery land definition is generic and covers all of that land.
Okay. Right. Anybody got any views on that?
Member Fogarty, just so there's a requirement to secure the land for the road.
Yeah.
And just to note that in addition to the road itself, there are other things that are associated with that, such as drainage, which wouldn't be in the road. And it's just to understand there's an attenuation pond which would need to be altered, and other drainage matters that would need to be cleared up. And I'm assuming that those works would extend beyond the road itself.
Yes.
And just a question as to, when you talk about the land for the road, does that mean all of the other bits and pieces, drainage and areas of landscaping and so forth? So you secure the road, but then if you go to try and implement drainage works, for example, and they're not within land you control, I can see that as being a problem. Is that taken care of?
That is, Mr. Dygan, yes. So if you turn to the definition of backchild link delivery land, it states the land required for delivery of the backchild link and associated drainage, which you just mentioned, landscaping and accommodation works, which includes such additional land or rights as may be reasonably required from time to time, perhaps including construction compounds, etc., etc. That's on page 28.
Thank you.
Anything else? Ms. Bonny?
Oh, sorry.
Yeah, you go
Oh,
first.
No, sorry.
I'll let.
Okay. Young. Sorry, I didn't see you.
So again, just falls into the category of we don't know what the value of that land would be. Mr. Pereira quite rightly has made clear that the council can't say what they intend to do. And you'll notice in the clauses, the county council obviously can't, in this agreement, tie the hands of the members. We need to make that clear. It's a matter for the members of the council ultimately. But obviously, we're a higher authority, and this is I have said this before, but it is in our local transport plan. So certainly, the advice of the officers would be, this is appropriate. It ultimately rests with the members, which I think, if I'm not speaking out of turn, is exactly the position the council, the borough council, have to adopt for what their intentions are for that land as well.
Just before you speak, Councillor Bonney, that land at the moment isn't owned by the council, is it? I don't think. Although there's I can't remember the name of the deed. Novation agreement. So, is the novation agreement, is there a possibility that it might not go through? Because that's important, because it might not then be owned by the council at all. So,
Ma'am, there's every indication that it will go through.
well, there's every indication.
No, so it's to do with making sure that the land that gets transferred is properly defined in a plan. And so far, the developer transferring the land has been giving us erroneous plans and trying to transfer things which aren't the right geographical extent.
Doesn't sound very good, does it?
No, it's been going on for a long time, and so we need the correct plan, and without that, and so that's where it's at the moment.
Obviously we'll know, or presumably, well, maybe not. It will be certain by the time this deed is signed, one way or the other. But is there any implication if it weren't to, for some reason, to be, transferred? So it was actually private land.
So imagine a situation where it doesn't get transferred to the council and remains in the ownership of the Stones Farm development. Then it is still within policy AS1, the safeguarded area. So you couldn't build houses on it, for example. It's also designated local green space, which is a restrictive designation which doesn't allow buildings other than for things like, sports changing rooms and so forth. So it is as a country park. It's meant to be a country park. That's what it was approved as part of Stones Farm. It's also within the safeguarded area of policy AS1, and it has a local green space designation. So whilst it could remain outside of the council's ownership, it would then be for the developer to try and reach agreement with whoever does own it.
Yeah.
And then if they're not able to reach agreement, and I'll just defer to Victoria as to what would happen in terms of the same provisions in terms of KCC acquiring it?
Yeah, that's correct. The same provisions would apply.
So what you said about it being included in the
definition of
the back-child linked delivery land, that
correct.
would still apply. So I suppose that's okay then.
We've just worked on the assumption it will transfer to.
We have, I know.
To Swale. I think is it the Kent Home Building Partnership LLP that is the current owner of most of that land. So they're the ones
not
I think.
Stones Farm people.
I think they are. That's the people. That Stones Farm is the name of the site, obviously, and,
It's Hyde essentially, and Chartway were building, but Hyde.
Yeah, they've got some in area. I've got plans showing all the ownerships, and then the Kent Help. There's some house builders there, different house builders, but
if it doesn't make a difference, it doesn't matter.
No, I think we've just assumed. I hear what they're doing about the plans, and they're not sending the right plans, but we're just assuming that Swale will, stand up to that and then expect to receive it.
But even if they don't, and it just happens that it isn't in the council's ownership, it wouldn't matter because we've got this clause
ultimately,
that this is all part of the safeguarded
ultimately
land.
The CPA.
Yeah. Okay, sorry, Ms. Bonney. Right, you've got a point.
I think because it is designated as a open green space under the terms of Natural England, because this came to the council is in the process of as a SANG, it's for the benefit of not just Stones Farm residents, but neighbouring Vincent Park, as well as for the countryside gap and all the usual planning reasons. So I think it's obviously, if there's that covenant on it, then clearly that will need to be dealt with.
Okay. Oh, yeah. Okay, fine. Right, thank you very much. So, is there anything else to say then about this particular schedule before we move on?
Just a query, and it's really one for the solicitors.
Yeah.
This is in terms of 8.1.2 and 8.1.3.
Oh, excuse me. 8 point. Did you say?
8.1.2 and 8.1.3.
That's not the Bapchild Link schedule, is it? The Highways and Transportation
I think
schedule?
you're on a different schedule, aren't you? I think you're jumping ahead.
So this is page 13.
It's in the front end of the agreement.
Yeah, and then I'll tie that to the...
Okay.
So, sorry, you're looking at the whole agreement now, are you? Oh, I see, right,
so,
okay.
yeah.
Hang on.
So start at page 13.
Okay, hang on.
Release and exclusions.
Right, page 13. Yep.
No, just it's been suggested by my solicitor that where it says 8.1, say for clause 5.2, to include and paras 1.13 of schedule 12. So if we just go to schedule 12 and have a look at 1.13.
Hang on a minute. I can't see any reference to schedule 12 in there. Could you just read a bit out again?
Yeah, so at the moment it says save for clause 5.2, and what it's suggesting is adding an additional few words to say and para 1.13 of schedule 12.
Right.
And that 1.1.3 is on page 31.
Yep. Paying your costs.
Okay, so that's saying that the current exclusion we have for obligations in the deed binding individual owners or occupiers should not apply insofar as clause 1.1.3 is concerned, which says that you may not occupy any dwellings until such time as the link road is substantially complete.
And it was just a sense check whether that should be inserted.
So 1.3 of schedule 12, did you say?
1.1.3.
Oh, on page...
I've got it as page 31.
I haven't got a 1.1.3.
Under schedule 12, is that?
81? I haven't got
Sorry,
any 80s
85.
in here.
That's the printed out one.
No, so sorry, it's the cross reference he's referring to is on page 31 of the Northern
Well, that's
agreement.
1.3.
1.1.3.
Oh, I see, right at the top.
Right at the top.
I see, sorry.
It's all right.
Right, okay.
Victoria, do you understand where I'm...
I think I understand. I think it's saying that you could enforce against individual occupiers of dwellings in the event that they were occupying a dwelling where that road wasn't complete. Which seems...
If you think it's unnecessary, but I've raised it and you've looked at it, and if you're satisfied with that.
Yeah. It's not normal to have any caveats to that provision which prevents enforcement of 106 obligations against, say, individual occupiers of dwellings or statutory undertakers. It's a
position.
That's fine, ma'am. I've raised it and have the
Okay,
benefit
that's
of the
fine.
feedback.
I mean, presumably. Well, anyway, it doesn't matter. No. Okay. Yeah.
May I, just an observation. Is there a sort of an overarching unilateral undertaking actually covering the whole Section 106, basically saying if whatever parties don't agree, is there like a covering statement that says if people don't agree fundamentally on something and it's not mentioned in the S106, is there actually a process manage it.
So hang on a sec.
A dispute resolution.
Well, I'm sure there is a dispute resolution, but if a party who signed a legal agreement doesn't agree with it, well, they wouldn't sign it, would they?
If there was a fallout, something wasn't specified, there wasn't clarity on one particular point.
Ooh. Well, that's why we're having this discussion. I hope there is, but.
But it's to save arguments later that if you put something in writing now.
And so, what would you suggest?
I raised the point. I am not a legal. I do not know the answer, but I did put it
So
as saying, is there a way of putting it? But we think this is
Matters of interpretation.
Interpretation or things which have been omitted by accident from the S106.
There's a whole dispute resolution section.
If you were to refer to page 14 of the Northern Schedule, the Northern Part Agreement, as we're looking at the moment, from clause 11, starting on the bottom of page 14, the next couple of pages are devoted to dispute resolution mechanics, which are quite involved and involve referral of matters to specific experts depending on the nature of what is at dispute.
Just also to add, the dispute resolution clause doesn't touch upon any contribution that's payable under this deed, so that's not going to be a matter for yeah.
Thank you both.
Okay, should we move on then? Right, so we're going now to the next schedule, which is Schedule 1. Now, hopefully we can go through this a bit quicker. Page 33. Right. Now, I just want to go through the this part of the schedule 33 and pick out a few things which I've got queries on. So the first one is the bus contribution. Now, as far as I understand, this is a contribution of 2.2 million, but 220,000 per bus for 2 buses, 5 years of pump priming. Now, the first question, of course, has to be, how's that sum reached? Presumably there must be some sort of formula or something, which I don't think in the sole schedule has been made clear. I don't think anyone's disputing the actual need for the contribution, but it's just how it's arrived at to make sure it, meets all these Regulation 122.
Sure, ma'am. We have consultation responses from the Kent County Council Public Transport Buses Department, and so the figure was first sort of mooted with me, and we sort of said, well, what's the breakdown of that? And it includes like the physical hardware of the bus,
yep. Mm-hmm.
And then there's a calculation that they undertake to understand when the bus is first used, there may not be that many residents on site to use it.
Yep.
And then over time, the buses get full because the application site gets built out, and it becomes self-sustaining.
Yeah.
And they have an idea as to how that plays out through experience, and so they know. For the northern site, they felt it was 5 years, and I think for the southern site, they felt they'd need pump priming for 10 years, given the length of the build-out period. And I then spoke to some other authorities, and the same figure is used elsewhere. Then gave me a little bit of comfort that it wasn't made up. I don't have the detailed calculation. KCC may be able to do that, but this figure of sort of 220,000 is well used.
Oh, that's... I need to... I mean, have you got... You said that you had discussions and you were given all this detail. So have we got that in the inquiry?
It will be in amongst the consultation, but I don't think all of the consultation is within the core documents, and I can make sure that that portion is.
Okay. I mean, I need to know why, for example, it's 220,000 per bus and not 240,000 per bus. So it needs to be accounted for, really. And I suppose I did have the question as to why the southern site is 10 years and the northern site is only 5 years. Given that I'm not sure that the scale of the site is, I don't know. I mean, why would it be any quicker, given that you've got the two villages, haven't you, in the south? Why would it be quicker in the north site? Why would you get to self-sufficiency in half the time, I wonder?
Ma'am, I can offer a view on that, having taken instructions. It's obviously the northern site, there's fewer houses and has a quicker build-out time, and it's the period that it would take for the bus service itself to become self-sufficient. So if the bus services that have been identified for the northern site assume a certain number of passengers, there'll be a period for which it needs pump priming before it becomes commercially viable.
Yeah, no, I realise that. I mean, that's normal.
Yeah. So that's the, I guess that's the distinction, so that there will be...
Yeah. Well, I'm just musing is why... I mean, is this 5 years from the completion of development, or is it 5 years from the commencement of development?
It would be occupation, when the residents start needing to use the bus.
So it would be the start. Well, given that it's, I think, a 10-year project, the pump priming would stop halfway through the build, wouldn't it?
So, yes, and in terms of more broadly how this would be coordinated, when it would start, and whether you put one bus on to start with and then move to two, and what routes they would take, where the bus stands would be, bus driver facilities, bus stops and so forth, really does need to be coordinated, and we don't have all of the details now, so there's a suggestion that there be a bus delivery and management strategy, so we can understand the detail of, you know, are you running a service an hour or two a day, and exactly how you would do it. I think Kent County Council have also yet to think about which bus operator it would be. So there's a number of things that need to be determined, and hence the bus delivery and management strategy.
Yeah, but we've only got one chance, unfortunately, to make sure that the amount of money is sufficient, and that's now, isn't it? And you know, there's no, you know, if it's found not to be and the bus fails, then that's a big part of the sustainable transport strategy that's in peril, isn't it? Because that's important. The bus is important, isn't it? Important plank of the argument, really. Yes, Miss Bonnie.
Exactly, and it goes back to what I think I said at the previous meeting, where we've had experience of this, and okay, it was in the south around the science park, but where we had commercial operators, another was brought in that was a pilot scheme, which probably was a good deal at the time for whoever arranged that, but it wasn't a good deal for the residents who used it. It became unsustainable, it didn't continue, and it demolished the commercial service. So we've got that history, and what we don't feel that is a robust way of dealing with it, given the length of time for the development. And I echo your comments and thoughts on that. I think obviously on the A2 there, which is critical to this bit because we're talking about the northern scheme, is, we've seen a winding down of bus services there from 4 an hour to 1 an hour. And there is some money that has just been claimed by KCC for the Stones Farm one. Now, I don't know, I haven't seen the detail of what the KCC bus officers have said there, but taking those into account and when those come in live, how they impact on each other and what that does to the services.
I suppose that, on them, someone...
Because we haven't seen a plan for that money that was from Stones Farm, and I can't relate that to what's in here to see if it's robust enough.
Madam, could we perhaps bring in the applicant's highways consultant who's joined via
Mr. Wild, yes.
Teams?
Are you there, Mr. Wild?
I am. Morning.
Good morning.
Morning, Mark. I think one of the points you were highlighting there was the differential in time periods between the northern and southern contribution. I won't take you to all of the references, but if we look back at the various sustainable transport strategies, one of the key differences between the north and the south is that the north will, to some extent, bring forward diverted and additional services that serve a wider area, such as linking Teynham through the Northern Relief Road to the employment areas. So the opportunity for off-site patronage is quite substantial on the northern scheme, which does factor into the overall time period that might be necessary to pump prime successful services. That's slightly different in the south, where the south derives most of its patronage from the development itself. So I just thought that might be useful as a contributing factor of why there's a differential in part.
I don't know when the bus services would actually commence, because generally they need a certain minimum, don't they? Even if they're being subsidised, they need a certain minimum to start with. So they don't usually, I wouldn't have thought, start at year 0. But it just seems that if the site's being built out over 10 years, I don't know, I'm just a bit concerned that, halfway through the build, when people are still, it's still a building site basically, that then the patronage of the pump priming would stop, or do you think it would start later? I mean, how do you envisage that?
If I might come back in again. I think yes, you're right. There will be a period of time once the service commences. But again, the criticality of pump priming is about sustaining viable patronage. That's the critical point, obviously, and therefore the ability to derive additional patronage from other sources is critical to achieving that point. So it may well be the development is still being built out. But those services this will have fed into KCC and overall consideration will hit that point of viability much sooner. So the pump priming may come to an end, but if it's hit fair deriving revenue patronage levels to be viable, particularly taking on board other sources of patronage, and that link, say for instance, Teynham to the north, which is actually in part delivered by the infrastructure as well, the opening up of the Northern Relief Road. That's quite an important part of that routing. That's a route that's not available today that will become available. While the pump priming will finish, the patronage will be there and the services will be viable. So I think there's every confidence that can be achieved on the north. I think the longer period of time is needed on the south. So I think the anomaly here is probably the south, not the north. The north is felt to need longer to establish that viable patronage, because it's more dependent on, if you want, services that are dependent on the patronage from the development itself. So that's the critical difference between the two.
Okay. Just seems 5 years is not a very long time, that's all. But
we agree.
I I take what you say. I mean, obviously,
Just to add, it's not fixed. I don't think it's fixed to 5 years. I think that's how the sum's been calculated. So there's a bus strategy required to be approved. So obviously, as
well, the instalments would presumably be in that they would be decided by the strategy, would they?
yeah, so the strategy may well be that you have subsidy running over a longer period, but that's how the subsidy amount has been calculated. So I think it's just important it's not quite as linear as that.
I see. Okay. Okay.
Sorry, Ma'am, if I just to add to Mr. Gearing's comment there, just on the final point, I believe, in case he can interject if I misunderstood this point, but the intention is that that period is extended as revenue comes in. So the period can be extended. The money is fixed, if you will. It's the time period of that pump priming can extend if fair revenue is meaning it isn't all needed to sustain that service. So it can end up being an extended period. That's my understanding, that it's a fixed amount of monies and the time is variable. So obviously if you're getting 50% of your revenue deriving you're covering your costs, then you don't need all of that cost to run it in those early periods. So as Mr. Gearing said, it's very much a variable on the time. It can be extended.
And you're satisfied that the contribution would cover the it would be sufficient to ensure that the bus services were provided in accordance with the strategy? Are you?
Yeah. Sorry.
Well, the money's enough, in other words.
Yeah, that's quite the amount that's been used for the calculation purposes is something that KCC have used elsewhere over the last few years. A scheme the name is escaping me. It's in Tunbridge and Malling that recently got approved using the same mechanism for the sort of the price per vehicle. So it's quite an established amount, and it's been subject to inflationary pressures. It was a little bit lower a few years ago, and that's been adjusted for in the amount we see in the 106 now.
Okay. All right. Mr. Dyken, can you provide more information then, please, on the...
So just in terms of the consultation response, that's at CD 4.30 for the Northern scheme.
4.30.
And so the PDF page, or page 13 and 14 of that document is the County Council's response.
Okay.
Colin, do you have anything to add? I think it's page 13 of our consultation response for the Northern application, isn't it? Yeah. It's set out there.
Look.
But it's not telling you anything, I don't think, that you've already...
Not telling me anything.
Well, it's not telling you anything more than you already know. No.
Oh. Well, what I want to know is how some of the money's been arrived at. I mean, you must have a form. I mean, it's not just a finger in the air, is it?
No, there is. I don't have it to hand. I'll be glad to go back to KCC and get them to formulate a note that explains their rationale for the 220,000.
Yeah.
And I imagine that'll take a week or two to get back to you.
Is that all right? Whoever's going to do that, I don't know.
I'll coordinate.
Yes, we can take that back. That's not a problem. I mean, I suspect, and well, yeah, I suspect it's something to do with it would be a KCC public transport commissioning services, and that being the average cost of operating one bus for the services that they commission.
We need to know how
absolutely.
it's arrived at. So you're going to provide a note. I mean, that would apply also to the southern site.
Yes, ma'am.
For both sites. Yeah.
It would, yeah.
All right. Okay. Well,
Just one further note.
yes, Mr. Gearing.
Under bus delivery management strategy, clause C2, there is provision built in that does allow the owner to commission bus services directly as well.
That would be an alternative to paying the sum.
So that could either be
part of it.
directly providing services or just directly commissioning them with providers.
Can I come in on that, please?
Yeah.
Because that is a key concern. That's what's happened before, and I think that is part part of the problem, because you can have an impact on the other services that then ends up being a negative impact on the communities that use those.
It would have to be agreed with Kent, so they would.
I think there should be some community input on that, because given the history of bus delivery and development locally, I think we want to have a good handle on that.
Well, I mean, in terms of, the legal agreement is made to to the council and who are party to it, and the county council. Obviously, unfortunately, or from what you're saying, the community isn't a signatory. So, I mean, you'd have, one would hope that the county council would reach out to the community, but, that can't be dictated, I don't think.
It does say the approved bus, so for the definition and the approval of the bus delivery and management strategy, in the last paragraph it says the strategy may be approved from time to time by the county council in consultation with the borough council. So there is although it's approval by the county council, there would be that ability for the community to feed into the borough council.
Well, I think that at the very least they could consult with the parish councils.
Well, yes, but I'm not sure that...
In consultation doesn't mean you have to be a signatory. You can ask them, or at least notify them, because that's what's not happened, is there's not been that consultation.
Mm-hmm. I mean, the borough council are supposed to be the democratic body, aren't they, that represents people in its area. Statutory, I mean. But, I don't have an objection, but it depends on... You'd have to define which parish council. I don't think you could just say parish councils generally.
I think we're comfortable with the way it's drafted. It has the borough council there. That would provide opportunity for the borough to speak to their ward members, for example.
I think the key parishes here would be Batchild, Tong and Teynham. Sorry, for the Northern Scheme, I'm talking to this document.
Batchild, Teynham and who?
Tong.
Tong, oh yeah.
Yeah.
The problem is obviously with they connecting to the Northern Relief Road into Merston and other places in Sittingbourne, but they don't have parishes to represent them, so that's why the borough could cover it, surely.
So therein lies another problem, because we are assuming, aren't we, that the Northern Scheme goes ahead of the South.
Well, it has to...
in terms of sequencing.
I don't know, really.
And the interrelationship between these two agreements and how they come together.
Okay, well, can we do one thing at a time? I think it's a bit tricky to actually... I haven't ever seen such a clause in a legal agreement. I have to say, despite dealing with quite a few contentious ones, I mean, the borough council should be able to consult with others if it feels it's necessary. I mean, I do take your point. I mean, I know you've had problems, but I don't know if anyone's...
I would agree with that assessment. I haven't seen a 106 which specifically requires a borough council to in turn consult with specific parish councils. I think it's up to the borough council to determine what is appropriate consultation for any particular 106 approval required.
What do you think, Mr. Dygan? You're the borough council.
I mean, there are requirements from a planning perspective with who we consult with. They don't typically relate to Section 106 agreements. They relate to planning applications. So I think it's helpful that there's a requirement to consult with the borough council, but then the borough would then need to just decide who it further consult with. So, for example, this relates to buses. We'd make sure that we're talking to KCC so we understand what the bus strategy is and whether everybody's agreed with it. In terms of whether we would consult with the various parish councils and so forth, I'd just need to discuss that with my manager, but we don't usually consult with the parish councils on Section 106 agreements.
So if I may, Stones Farm, which is part of this red line boundary, had an amount set aside. It wasn't till I raised it in inquiry that amount of money was then transferred to KCC, and I haven't been notified as to what that's being spent on, and neither is my parish council. And just as a matter of clarity, I missed off, I'm sorry, Linstead. I should have added Linstead to that list because the A2 dissect is the dividing line between Teynham Parish Council and Linstead Parish Council. So sorry, Action Group.
I don't think they're a Rule 6 party, are they? Or are they included in an Action Group?
Yeah, they're part of the Action Group.
Okay, sorry, yeah. Okay. Actually, you said that it's actually KCC would consult the Borough Council, I think, rather than the other way around, isn't it?
Yes.
So,
I mean, if there's a requirement for the borough to then consult with parish councils and so forth, I'd need to revisit the monitoring fee. That sounds like a much bigger task.
Well, I'd have to think about that, but at the end of the day, it's your Section 106, and I'm not sure that certainly that would be a clause that the Secretary of State wouldn't be able to turn the application down on the basis that hasn't been included in it. So you have to think, is it necessary?
It's quite, from the borough's perspective, buses are a sort of a specialist public transport matter, and we defer to KCC in relation to that. I wouldn't be able to make decisions in relation to bus routes. I'd defer to the public transport division at KCC for that.
Got any views, KCC? Or perhaps people who are at the business end of it? Don't know who. Mr. Finch, Mr. Millard? I don't know.
It's not something I've come across before where we consult with the parish councils. There are a lot of moving cogs in this because of the way that our public transport team have to assess how the buses are going to operate and how best to make use of the funds. So it's.
Let's just add. I think we the buses need to operate on the most appropriate basis, as run by the operators in consultation with the county council. And if you start designing it all by committee, you're going to end up with probably something that doesn't really satisfy those that actually have to run it. So I'm going to suggest that we really wouldn't want that in there, just for operational reasons.
Just go back to the justification for the bus club. Just going back to the 220,000, when would you want a note on that in terms of the further justification for how they calculated it?
Well, we have got another Section 106 session,
yes,
believe it or not, later on. Obviously, if you could do that, before we come back, I would think.
Sure.
That would be very helpful. I don't really want to set a time. I know it's, people are on holiday and so forth, but before October. Okay. Well, I think you've made your point, Miss Bonney. I'll have to think about that. Thank you. Okay. Thank you very much. So, can we go down now, please, to the framework travel plan is the next thing on my list. Now, I would like to just understand about these various levels of travel plan. So, we've got basically a overarching travel plan as part of the sustainable transport strategy, I think. We've then got the next level down is the framework travel plan. Then got travel plans relating, I'm not sure whether that relates to each phase, does it? But anyway, below that, we've then got occupiers travel plans. So it's quite a, a hierarchy, isn't there? Is that right? Have we just got the 3 levels, or are there more?
That's correct.
3 levels. So obviously there's need for the overarching one, and that's dealt with is it a sustainable transport strategy?
Forms part of the overarching sustainable transport strategy, which at Lim A refers to a site-wide travel plan.
That's right. So site-wide, so that needs to be considered, doesn't it, before anything else is provided. And then, so in terms of phases, again, we've got one of these parameter plans, haven't we, with a high-level phasing plan. Now, presumably in the either conditions or some other place in the legal agreement, we've got a requirement for detailed phasing plans, have we? That sit below those.
Excuse me.
Heard about those?
Yes, there are in the conditions, but there are also some reference to phasing in the 106 as well, which.
But they will come below. I mean, they're more detailed than just the ones in the parameter plan.
Correct. Yes, the ones in the parameter plans are effectively explaining where construction activity will take place as a kind of sequence over a number of years. So.
Yeah. So that so when we're talking about phases. Have we got a definition of a phase, actually?
We do have a definition of the phasing plan by reference to a plan.
We haven't got a definition of a phase, though, have we?
We do, yes.
Have we? In here?
In the front end of the agreement on page 8.
Front end. Right, okay, let's just have a quick look at that then. Phase. So, means any of the 2 spatial phases shown on. Can we just get up that phasing plan then, please? I don't know where it is. CD for the north. I'm presuming you mean the phasing plan is the one that's being approved. If this is approved.
That's the intention.
So that's CD.
Yeah, 217.
It's 2.17, 2.17.
Okay. Oh yeah, there we go. Okay, so those are the phases, and they are so just 2. Hang on, let me just can't read that. Right, okay. So this is what's meant then, is it?
Yes, so when we defined the framework travel plan by reference to a phase, we mean the phase is shown in this phasing plan.
Right, I see, okay. But there will be a detailed phase, more detailed than this, you say? Yes?
I don't think we're going to get into the day, but yes, there's a sort of effectively a next stage below, if you call it tier 2, we've discussed it a little bit, but it's almost saying actually what's going to happen within these broader phases. So for instance, what is the housing mix in there? What's the affordable housing element as well? Again, it does interact with the 106, but there's kind of just basic design sort of development and everything else within those phases. So.
But when we're talking about phase in here, we're talking about the strategic phases.
That's right, yes.
That's right, yes. And we have a definition of sub-phase, which is anticipated to cover those more detailed parcels that Mr. Bashforth was just referring to. But that will be fixed as details are approved. It's not the same status as the phasing plan, which will be appended.
Righty-ho, I see. Okay. So we're down to the framework travel plan, which is just a travel plan for each of those 2 phases then, which presumably has to comply. Does it say it has to comply with the overarching travel plan somewhere?
Yes, it does.
Okay. Okay. Yes, right, okay. Fine, thank you. So the highway works. Now the on-site highway works, I'm presuming that the on-site highway works also include the Northern Relief Road sections within the site, do they? Does it? Sorry.
Those would form part of the definition of transport infrastructure.
Right. So they're not included in the highway works then?
That's our understanding. There's essentially two levels of works. There's the Northern Relief Road, which obviously is dealt with in the schedule that we spent some time looking at this morning.
Yeah.
And then when you get down to the sort of phase level, the detailed level of where the houses are, that's when you're talking about the highway works as defined in the agreement.
So they're all the residential roads and...
Exactly.
And presumably the junction with the A2, that comes within the Northern Relief Road works?
Yes.
Okay. Thank you. So in that case, what are the off-site highway works? Oh, I see. Yeah. Okay. No, don't worry. Yeah, that's fine. Let's just keep. Yeah.
Madam, could I just raise a point on this?
Yes.
Because it's the same point in relation to the Southern Agreement in terms of the definition of on-site highway works. National Highways was concerned to clarify whether that included the motorway junction or not. And as we currently read the agreement, the definition of on-site highway works B refers to the creation of any new roads within the development, which are proposed to be dedicated and adopted as public highway. And that is very broad and could arguably include, for example, the Northern Relief Road, Southern Relief Road, and the motorway junction in the case of the Southern Section 106. So we just wondered whether maybe there should be an exclusion for those pieces of infrastructure if they're not to be captured within on-site highway works.
I would think so.
Yeah, so that would need to be redrafted then to exclude those.
Well, has anyone got any comments on that?
I think that's a fair comment.
Can I ask a question?
Yeah.
So effectively, we've got 2 sections of work here. So we've got internal and then the strategic. If there's a dispute on the boundary, how will that pan out? Could the applicant put a unilateral in on that, or how does it work?
So can you just explain?
So if there's a dispute over, because at the moment you've got a grey. If I look at that plan, the phasing plan, there's a, we don't know the precise location, but it's as good as we're going to get at the moment. But as things pan out, it might change. And you could end up with the strategic road network encroaching on estate layouts, etc. Or you could end up with, redesign, things don't work,
Well, this parameter plan is actually to be approved now. So the corridor of the road as I understand it, the corridor of the road and the uses in the blocks are fixed. Is that correct?
Important to read them in conjunction with the other parameter plans, of course, isn't it? So
Well, yeah, but I mean...
Yeah. But you're right, this is effectively the framework, and we need to look at the development parameter plan. And there's also, do you remember the green plans we talked about at the start of the plan as well? So there are other things that will be approved as well. And then, again, this comes to the conditions. It's all about what will be approved when. And we know we've got to deliver the strategic roads first as well. So it should be very clear that actually the sequence, we will have those strategic roads first. They will be approved. Other things will be approved consecutively.
Sorry, may I ask, just building on that, just following on that line of thought. So you've got the strategic road, so the Northern Relief Road, understand that, get that. What about the road from where the Northern Relief Road comes down to the A2, there's some sort of roundabout or some sort of junction, but the road that goes from the A2 and goes up to Lower Road, because that's going through a phase 1 housing development and a phase 2, so the light blue and the dark blue. So the question is, does that get built all the way and connects up to Lower Road when the first phase of the housing is created? Or do you get a road that has a limb and doesn't go anywhere and then the next bit is built on? Does that make sense? So it's the road from the A2, the roundabout on the A2, that then weaves its way up through to Lower Road and with the junction, or very close to the junction of Frognall Lane.
Where the bus link goes in, out.
And without that road, you don't get the bus sustainable forgive me. Without that link, you don't get the sustainable transport, the ability to run a bus service, because they wouldn't be able to go up to the station.
Ma'am, if I can assist, this is an outline application with all matters reserved, and it's a very good point. But in terms of layout and access, they'll need to come forward with the reserved matters, and there's a series of conditions which also require phasing to be dealt with, site-wide phasing, but then sort of like sub-phase phasing. And those details, and exactly as you say, the council will need to grapple with that to make sure that the sequence of events as to when the roads go in and so forth, and the timing for the residential, but that all needs to be resolved. We don't know yet because of the outline nature of the scheme, but to give you some comfort, there are conditions recommended which relate to reserved matters to mop that up, and other conditions to look at phasing. So access is a reserved matter, and that detail, that's all roads, parking, and so reserved matters, this is where if we got a reserved matter for access that was a road to nowhere, then we potentially would not be able to approve that unless there's some logic as to. So it could well be that you end up with phasing plans and reserved matters for access that do things which might seem to go beyond a parcel of housing, but there could be a logic in that, and that further phases are going to plug into it. And it could be, for example, that you need to create haul roads for the construction phase, which later turn into actual roads and so forth. But so yeah, very relevant, but it's an outline application, all matters reserved, and that is what the reserved matters and phasing conditions target.
Well, I think that the phasing plan would need to come, or sub-phase, or whatever you call it, because we have got phasing plan, but sub-phasing plan would need to be approved before the reserve matters. I think that would need to be upfront.
Correct.
For any development.
That's the intention. So at least you know what's coming in terms of
what's coming where, and then you get reserve matters for each phase. Right. I hate this thing sub-phases because it's so confusing. Yeah. I mean, anyway, it doesn't really matter. But anyway, as long as we all know what we're talking about, the sort of sub-phase plan.
And then there shouldn't be any risk of effectively designing or implementing a scheme that's incompatible, because it's telling you at the different parts what's coming forward when and what's being designed.
Yes, but I mean, it might be that phases are built out concurrently, of course.
Correct.
So that's but certainly reserved matters will need to be provided on each sub-phase before any development can start. So if there was concurrent development, then you would get to lots of concurrent reserve matters.
And the important thing is we have to agree what those sub-phases are with the council. So if it's
Yes.
got to make sense as a sort of a package, if
Yeah,
you
of
like, of
course.
things that come forward together. So.
And it's got to all tie in with the parameter plan, so it's all got to fit together properly. And it's important to, always with these big sites, it's important to have a site-wide vision, if you like, so that everything actually does fit together properly, I would say.
Is that? But that's
Okay.
Yeah, they've answered.
Right, okay, thank you. So, yeah, okay, let's carry on then. So the off-site highway works then. Now they are various things that are identified, aren't they? I'll just have a quick look and see if I can find them. Where are they? On-site, off-site, here we are. And I did wonder actually, we talked a lot, didn't we, about the Woodstock Road corridor. Now, I'm presuming we're just talking here about the junction, are we? We're not talking about the sustainable transport corridor. Is that right? Just the junction?
Should I bring in Mr. Wild? Would that be helpful?
Yeah, Mr. Wild can. But Mr. Wild,
Beat me to it. I was just about to speak. Yeah, let's go. Yes, so you're quite correct. Yes, so the these junctions that are referred to here were identified as being materially impacted under the Northern Only scheme, and therefore subject to mitigation that is to be determined under agreement with KCC. They, at the time of the planning application, had indicative mitigation solutions. The work that was undertaken for the southern scheme to advance those further to alternatives, signalisation, etc., may well form a component of those when we come to determine that mitigation. But it is, as you correctly say, localised. In the northern only scenario, would be restricted to the junction rather than the corridor, which you've seen in the other work that's been done as part of the overall cycle improvement corridor. And
they're obviously all justified, are they, in the transport assessment somewhere?
Yes, so those were the residually impacted junctions that required mitigation under the north only scenario, hence the reason they've been identified in terms of capacity improvement works, alongside also what you also see referred to there are the alternative sustainable corridor. So in this case, this is the A2, improvements to the A2 corridor with respect to cycle facilities. So that's a different, just to be clear, a different corridor for cyclists in the case of the north.
Yeah, I understand. I was just wondering about the Woodstock Road one. Can you just give me the because there's other improvements. Could you just tell me where I can find it in the transport assessment? Have you got a CD reference?
So is this the assessment that determines the need for the improvements?
Yes, indeed.
Yeah, so that would be in the northern TA, which will be CD 1.19.8.
Okay, that's great. Thank you. Okay, thank you very much. Good show. Righty-ho. Yeah, I might need you again, Mr. Wild, so don't go away. Overarching sustainable transport strategy. The only thing I wanted to explained, which I don't think we've really discussed actually, was the public transport hub and what that's all about. Did we talk about that at the inquiry? I don't think we did we?
I don't think we did actually in much detail. So this is
what does it mean?
Excuse me, sorry.
What does it mean?
Right. Okay. So it's intending to find a location, particularly in Highsted, where we can potentially look. We had some engagement with some of the bus operators that were looking for alternative opportunities for layover provision, etc. So if you're operating a service, at the moment there's a lot of focus towards the Sittingbourne station area, and there can be quite a lot of congestion around the station, in the town centre area. It's also looking at possibilities where we may have adaptation towards electrification of vehicles, and therefore a need for an area where we may be able to have, or the bus operators might look to use en route recharging. And it's also looking at opportunities for combined mode trips, so where you may have, say, combined ticketing or combined timetable information, where somebody can go to that hub location within the, particularly at Highsted, and do a combined journey from that location. So there were a number of factors that come in. It was, again, so my memory escaped me, the local bus operator that was keen to discuss options such as this, particularly for layover provision. So it's about trying to get a focal point within the development where particularly buses can be provided the facilities they're required.
So this would be within the development, would it?
Yes, that's what's envisaged there, yes.
So in just the northern site then?
Yes, actually that's a fairly good point, that in terms of on the northern side, it may be a carryover from the south actually in that respect.
Is one necessary then or not?
I was talking it from a southern point of view actually, so you're quite correct. This is the northern section 106, isn't it? Yes, absolutely. That's a very valid point. So that may be a erroneous entry in the 106, the north.
So we don't need one of them for the north?
That's correct. That's correct, yeah.
Right, that needs to be taken out then.
Ma'am, may I just ask a question? So, just for clarity, if only the northern site went ahead, would you surely not need one?
I don't know.
In the provision in the north.
I don't know.
Question. I don't know what the answer is.
Mr. Wild? You said no. You don't need one. I should think.
No, you don't. I mean, that's similar to the earlier question I gave about the bus provision for the north. It is going to be more dependent on, loath to say diversion, but complementing existing service provision and adding to the routes that are provided. The southern site is much more about new provision to new areas, to entirely new settlement area, and therefore that's where that new infrastructure comes in, is quite useful, particularly with its focus towards Sittingbourne, and that's some of those challenges of the space that's available in that area. So we're talking a much reduced level of sort of additional burden on the network and the services for the north.
All right. Good. All right. Thank you very much. So coming now then to public rights of way. So we've got the public rights of way contribution. Right, now this looks as if first of all so we've got £55,350, quite precise really, so somebody must have thought about that and decided that was appropriate. So have we got somewhere where it explains exactly how that sum has come to, please? Who's going to speak?
I'll speak to that, Mum.
Okay, Mr. Finch.
So Mr. Rustling, who you met earlier on, many weeks ago, did a calculation effectively in respect of the surfacing works per metre, whatever that were required on the various impacted public rights of way, and they are then multiplied up for the improvements, and that's how the contribution is calculated. So it's a
Is there any, have we got any information about his calculations, or were they just...
They were shared with the applicant, I believe.
I mean, from our point of view, we had a lengthy period of going back and forth, looking at exactly how the county council had looked at the costs of upgrades, which paths needed to be upgraded, ensuring there wasn't duplication of upgrades to paths. I think some earlier paths have been identified that then couldn't be... no changes could be made for them because they went through a designated area in the SAC and SPA and things. So that information is all available. I don't know exactly where it is at the moment. That's the only question.
Yeah, I don't know whether
I don't know if it's in the documents that you have.
Right. Well, someone tell me at some stage where I can find it?
I can have a look, Mummy. I don't know if there's a CD. I mean, for instance, just as an indication, so for public footpath reference 191, it was agreed that an improvement was needed. It's a length of 177 metres, and the ask is for £7,965 in respect of that path, and that's for improvement works to that.
I think. Sorry to interrupt. I think there is a CD with some of this on. So CD 4.37 seems to have some calculations on. That may not be the right one, but there is certainly some calculations in the CD references.
I think certainly as well the PROW statement of common ground that was established.
That got some in it?
I think we should double check it because it may have this breakdown in it.
I mean, it might just be, the cost. The cost of resurfacing, for example, and
that's exactly what it relates to.
There's some sort of calculation done from, talking to contractors how much that is, that sort of thing. But
that's the work I understand. That work was done,
Yeah.
and there were really detailed breakdowns. So if it's not in the statement of common ground, maybe we could just add it to it or something. There'll be a way of doing that, I think, to give you the certainty.
Well, I would like to see that, please. If it's in there, fair enough.
I think it's only just been put in because it's dated, isn't it? Oh no, it's not. Sorry.
Okay. Can you check? Yes. Okay, thank you very much. The King Charles III England Coast Path, which we talked about, that some people will be, I think especially from the northern site, is quite close, isn't it? Part of it. So there is this sum, which is 143.7 thousand, I think. But I think that's the same for the south. So I'm just wondering, that's for both sites, I think, isn't it?
Yeah, that sum is agreed for both sites, but the apportionment hasn't yet been established for the purposes of the 106. The intention was to split it so that part of that sum is secured under one agreement and part is under the other.
So, the same will apply, but we need to know how that's worked out.
I think things have moved on this and maybe haven't been caught up in the drafting. I've just contacted Mr. Finch and we'll move that forward as quickly as we can.
What, the sum or the...
Yeah, both the sum and the evidence behind the sums, and we'll feed that into the teams. I think there's been quite a lot of work on the PROW improvement strategy that was discussed at length in the PROW roundtable session.
Yes, no, it has, yeah. But I don't think we discussed the sums, did we?
No, I think we've agreed some, so I think it's just a case of us passing that on to our lawyers.
The statement of common ground agrees the sums for them.
Yes, but did it agree the split? I'm presuming it's divided up according to number of dwellings in each, proportionately, is it?
I'll double check, Mum. I think there was some discussion about the both developments impacting upon the King Charles Park.
Yes, we did discuss that.
Yeah, so I think it was...
Yeah. I'm not saying that it shouldn't be provided. What I'm saying is I want the rationale between how it's split and, which I can guess, but I need to be told.
No, understood.
And how the sums worked out exactly, please.
Yeah, we will get a copy, presumably.
Yeah, there'll be inquiry documents. No, neither have I. Okay. Right, so again, somebody needs to provide that breakdown. They can be provided together, as one document, if you're quite happy with that. Okay, good show, thank you. Good, all right. Now we've talked about the station contribution, so we don't need to deal with that. So the next one, yeah, the transport infrastructure, which is on the bottom of page 38, top of page 39, which is a strategy. And my question is that we've got various junction. Hang on a minute. Transport infra. Oh no, it's the detail of the transport infrastructure is on page 39. It might be one again for you, Mr. Wild. So again, could you tell me where I could find the in the TA, just for my note, where this will be evidenced from, please?
Are you looking for the junction references?
Well, just where it's the justification for the junction improvements, all these junction improvements, requirements for them.
So this is under the transport infrastructure.
Yeah.
Schedule. Yeah. So this primarily comprises the effectively the either site accesses or the delivery of the associated link road infrastructure. So it provides the clarification on.
Oh, I see.
So these are not mitigations per se, although they have a mitigating benefit, but they are the committed highway works in the form of the link road. So that is what you see listed in that location. So various junctions. So you can see there is a plan within the transport assessment, and in fact, is the junctions plan? Someone else may be able to assist me. Is that actually appended to the 106 schedule, the junctions plan, or do we refer to the transport assessment? Apologies. Maybe Victoria can assist.
I think we haven't quite bottomed out yet how we're going to deal with it. I think ideally we were envisaging appending something. For now, we haven't. We've cross-referenced the TA. I think we just need to determine what's the best way of ensuring that's clear as to what we're referring to. Well,
I would think it ought to be appended probably, but it doesn't reference. Sorry, go on.
No, so if your reference now, Mum,
yes,
it's in CD 1.19. Had it a second ago and it just disappeared. Sorry, that's typical, isn't it? 0.4.
1.19.4.
Yes, and then they're on. It's got the page number for you on PDF page 15, figure 4.1, and that's one of the volumes of the transport assessment. There's a plan with the junction lettering.
Oh right, okay, good. Okay, that's fine.
For the time being, but as to its inclusion, I'll leave that to others.
Okay, thank you.
Can I ask a question on that one?
Yeah.
Because I thought some of those access points had changed.
Okay.
So that's the one that this is appending to, is it? This is not likely to change, or this latest booklet that we've got that's come through?
You mean the latest section 106?
No, the latest. There wasn't some more drawings. Have they got new access points on or not? No? Is there any intention to change those?
Not the access points themselves, no. There's some clarifications on annotation and things like that, but no significant changes to any roads.
They should definitely be appended, I think.
Absolutely, I agree with that. Because we have concerns over T and 0 or O.
I think that's fine to append.
Things.
Mum, if it...
Sorry, T and 0. When you say got concerns.
Yeah, when I've got the map up in front of me.
There isn't a T, is there?
Sorry, T's not referred to in the 106, just to clarify.
So are they all on that plan? I haven't got it up in front of me, but...
I believe they're all on there. T is on the plan, but is not actually referenced down in the 106.
What is the purpose of these junctions?
Is that question to me? Sorry.
Yes, it is, I think. Sorry, through you, Chair.
The purpose of which you're referring to, because obviously the whole intention of the labelling here is to be able to break down the proposed infrastructure into a series of links and identify junctions in order for reference purposes, so that there would, each section could be treated individually. Hence the reason that you've got the junctions listed under Part A of the schedule and of the definition, and then the links under B. So it's intended to just be able to segment them out. So there's nothing on here in that listing in 106 that isn't already set out within the assessment and the work you've seen. They're just various. So G, for instance, is the A2 junction, which we've seen discussed previously. R, for example, is the junction at the A2, the other side of Batchild. So they're all just part of the infrastructure that we've been discussing at length during the inquiry.
Okay. All right.
Well, there's a number of junctions that aren't on this list that are on that map. That's why I was asking.
That are on the list but not the map? Or
They're
on the map but not the list?
They're on the map but not on the list.
Right. So why is that, Mr. Wild? On the map but not the list?
I think that's primarily T, I think, that Councillor Collins is referring to. Is that what you were concerned about? Is that correct?
Well, I'd just like to understand why there's not a complete list here. So is this just primary junctions?
So T, for example, so when the transport assessment was produced, in the absence of determination of access, as you'll see even more so within the Southern Transport Assessment, we identified all of the points where there was potential for some sort of access that might have taken place, and then there is a description in the Transport Assessment talking about what it may take, the form it may take through the determination process. As you can see, T in that particular case hasn't carried through and isn't identified on the parameter plan as a point of access. The others are. I don't think there's anything else on here that's, I think V possibly is shown as an indicative location and has moved slightly further up Frognall Lane. U is now identified as being active travel and bus only under Part A of the 106 description. So I think the only thing that hasn't carried over is T, if I understand correctly.
And what's O?
I mentioned O. I couldn't quite.
It's down Pantney Lane.
Are we looking at the same drawer? Apologies, I'm looking
well, sorry, if this is causing confusion, because the map that we are looking at covers north and south, so if you're going to append this, you'll need to update your map so it's north only, if you're going to append this.
Sorry, the reference I gave was for the north only. The one I was looking at in CD 1.19.4
is north and south.
Isn't
it?
Look at it.
No, the version I've got from the core documents is north only.
Is it north only? Okay, sorry, I might be on the other one then.
I would just observe that the junction plan is defined, and then it refers within that definition to the volume 4 of the Northern TA in figure 4.1, which is just the northern set of junctions. Mr. Wild is right. The only one that is on that plan, which isn't in the list, is T, and Mr. Wild has explained why T's not an off-site highway work anymore.
But I think it illustrates why it needs to be appended.
Right, okay. Can we move on then to the transport monitoring report? It doesn't really say there who's got to approve it. I'm presuming Kent County Council, but...
Certainly there's a clause 8 which requires the County Council to approve it.
Hang on. Right.
Yeah, it does state that it needs to be submitted to the County Council. Perhaps it's just slightly omitting the word for approval, which is, I think, just probably a drafting omission.
I mean...
That's certainly the intention. think.
Yeah, I think it needs to.
Yeah, when we refer at 8.2, should an approved transport monitoring report identify a need to deliver extra measures? I think it's just missing for approval. Submit to the County Council for approval. 2 extra words to add in that first clause would cover it.
Can I ask then, if that's not submitted, what happens?
Yeah, I think it would be a breach of the 106 agreement, and it may be that we tighten the drafting slightly further along the lines that myself and Bevan Britton have discussed about introducing negative restrictions where there's a positive obligation to do something.
Well, I think I've got a bit of a more basic sort of problem with this. This is for the monitor and manage, isn't it, Mr. Wild? The monitoring, transport monitoring. Is it for monitoring and manage?
Yes, that's correct. Yeah.
Which, as you said, is very important, isn't it? Because that's going to be basically what you're doing is you're doing something and then you're waiting to see whether anything more needs to be done through monitoring. And therefore then you put in your manage of whatever's, comes out of that, as I understand it, from what we're saying in the evidence.
That's correct.
Yeah. So it's probably one of the most important clauses, actually, in the whole of the, certainly of the sustainable transport section, I would say. And you're only going to require, and I might have read this wrong, I hope I have, it's only to be required to be monitored for what period of time?
On the first anniversary of occupation of the development, and then every anniversary thereafter, until the first anniversary to fall no earlier than 2 calendar years following occupation of the final phase of the development. So that's quite an extensive period.
Well, it's so 2 years at the end. So it is quite an extensive phase for the first the first occupation, but it's not very long, is it, for when it, towards the end of the occupation, years sort of, 17 to 20, it will be at maximum, 5 years. That's not very long, is it, really, for something so important, I would say. And only 2 years for the ones that are occupying it right at the end. Do you think that's probably a little bit light?
It's worth. Is it okay if I just come in on that point? Is that?
I would have thought it should really be in perpetuity.
Well, I think possibly one of the things we've tried to work on in this scheduling is to differentiate between the monitoring, the monitor and manage, and also the travel plan monitoring work. So without wanting to overcomplicate this or confuse it, there are 2 processes going on in this regard.
Just tell me again then, what are they?
Well, so the monitor and manage is we talked about the overall trip generation, and we talked earlier, or I talked previously about monitoring of areas of the network and seeing whether interventions are necessary. To some extent, there's a constraint to the opportunities that are available. You've only got a certain amount of time period to make those changes. The actual ongoing sustainable travel monitoring, so the travel plan will have its own inbuilt monitoring process within that, through the establishment of the overarching travel plan and the individual occupier travel plans. Those are the bits that we would like, you really would anticipate, particularly with occupier-specific travel plans, that can go on for much longer, where you can continue to make those interventions. So I think it's important to differentiate between those 2 forms of monitoring in this case.
So the travel.
There's only
okay. Sorry, go on.
No, so there's only to go on in perpetuity with the monitoring. you've got to make a decision at some point what you're going to do with the outcomes you get. So that while you're quite correct that monitoring is about waiting to see what happens and responding accordingly, you do ultimately need to make a decision as to what you're going to do. So you need a time period to say, how are we performing against our expectations, our vision-led and anticipated trip rates, etc.
Yes.
And then give yourself time to respond to that. You know, each year to say, well, we need to try something different and see if we can get to better outcomes. But you do eventually need to make a commitment to do something, whether that's to.
Well, you would, wouldn't you? You'd do it as you go along. I mean, basically.
Absolutely. Yes.
You know,
exactly.
See if it works, and then, as I understand it, you monitor again and see whether that's, you know. But why would you stop?
But because the end game of the monitor and manage process is potentially to implement off-site mitigation works.
Yes, of course.
For instance,
yeah.
So there will be a point at which you decide to do the physical capacity mitigation.
Yes. Yeah.
So once you've done that, really there is no need to carry on monitor. So to carry on in perpetuity beyond that point wouldn't have any effect.
Well, what happens if it doesn't work?
What happens if the mitigation doesn't work?
Well, yeah, then you have to try something else, possibly. I mean, I thought it was an ongoing, you know, that you try stuff. If it works, that's great. If it doesn't, then you have to adapt it or try something else, or something new comes along and you put that, you know, you sort of deal with that. I thought that was what you really were talking about.
No, you're correct with respect to the sustainable travel, monitoring and trying new measures with respect to sustainable travel. But the backstop is to do your mitigation of the problem. So you're trying to solve the problem by dealing with the causes, by making people travel more sustainably and use their car less. But the backstop of any monitoring and managing exercise is to implement the mitigation on the network in the worst case, the physical junction improvements, which is essentially your most pessimistic outcome, in our case in the main TA. So that's your backstop. You don't then carry on continuing to monitor beyond that point. So the changing up and doubling down and more efforts is to do with the sustainable travel. The worst case, if you are unsuccessful, then you improve the highway network. That's the back, you know, to ensure that there isn't a net severe impact. So it doesn't go on to the line of the development.
Right, but that's the sort of like the junction improvements,
yes.
And also, I suppose, would that include them putting in perhaps new cycleways or that sort of stuff?
Absolutely, yes. So if your monitoring is suggesting that the efforts that have been taken to improve cycling haven't derived the anticipated results, and as a result of that you're getting higher than preferred vehicle trip rates, then one of the actions to that may be to try alternative measures with respect to the sustainable travel options. So yes, that's where the trying alternative options comes from, but there does need to ultimately be a backstop to it in practice.
I suppose that backstop, you know, is the backstop too short, given that, you know, the development will be proceeding for 20 years or thereabouts, and so the last few phases, you know, there wouldn't be much time to monitor it and decide whether or not, you know, you need to, I'm sure that measures will have been put in all the way through, but at that point, you know, you're going to have a whole load more people needing to get about, and would there be enough time to do the monitor and manage for that, I suppose?
Well, I think it's important to note that we don't need the whole development to be able to monitor. So you're getting all the valuable information you need out of the earliest phases as well. So as your first, you know, let's say a few hundred units in the case of the north are coming on, you're getting your monitoring outcomes and the success or otherwise of the overall sustainable transport strategy from that sample alone, and that's telling you how you're doing. So yes, you're getting a bigger sample set, but that doesn't mean you're not getting the information. So you don't need to wait to see the travel behaviour of the last 10 occupants to know the success or failure of the development. You're seeing it from the very start through that monitoring process. So the 2 years afterwards is just to allow you to have that additional period afterwards if needed to extend it. You'll get a lot of value out of the initial period. This is why I contrasted this with the sort of ongoing travel plan efforts focused towards more towards an occupier travel plan monitoring, which is that more bespoke and localised efforts that come within any travel plan.
I mean, I think I was thinking, actually, I was talking about 20 years, of course, and the northern site is not 20 years, but I think I was thinking more, or be more concerned about the southern site,
I think
than the north, perhaps.
I may be correct in this one, but I think we had 5 years beyond final occupation in the southern. Sorry, someone from the team may be able to interject.
Well, we'll see that when we get to it. I think you might be right there, yeah. Okay, all right. Well, that sort of explains, I think that does explain. Yeah, okay. Well, that's what you want, and I have to think about that, obviously. Okay, anybody got any points? No. County Council's obviously happy with that, are they? Yeah. Mr. Menard,
yes, I think for the reasons that Mr. Wells explained, we came to the same conclusions.
Okay, thank you. Okay, well, how we do? Oh gosh, right, we're going to have a quick break, hadn't we?
Actually, could I?
Thank you. So,
Mum,
can I just yes.
So, have we done the transport review group, or you?
Not yet.
Okay, that's fine.
In fact, I think let's just have a break now for half an hour, shall we? So it is now. Well, let's say 20. If it's 1:20, let's say we come back at 1:50. Is that all right, everybody?
Can I just say that the lift is probably going to be out of action over lunch for about 45 minutes, so there won't be any lifts.
Okay. Well, I'm not allowing anyone to go anywhere. But thank you, yeah, Helen. Okay. Look at that. I don't want to take up time, but I just want to say that I think obviously there's a lot to talk about, and it is what it is, as someone said famously. But, you know, we're probably not going to get that far into the southern one. So there will obviously need to be more time for, now obviously we're not going to have any now, but there'll be more time needed in October. And so we're getting a bit worried about the programme. So I'm just going to float that, because I don't think a day will be enough for conditions for start, unfortunately. I mean, there's an awful lot of them, and I mean, I'm happy to go over them in advance and always try and sort of cut time, but I still think that, you know, it's quite possible that we need a bit longer than a day. I know it sounds horrendous, but I think we will, to be real. And we probably will need another day for section 106, because I mean we have, you know, the southern one's even a bit more complicated. Well, I mean it hasn't got the same land problems probably, but you know. So
I think,
you know, and so I think you need to sort of review our programme and have a look and see whether there's anywhere where we could save time, because really I don't think we can ask for more time, can we?
I'm gonna, just for my own part, I'm sure we all will. I'm gonna, once I've not, you know, planning cross-examination at the moment. I think I've got a day, for instance.
Yeah.
That seems quite long to me.
Right.
I know things have taken long,
Yeah.
but I'm going to try and get that down. And so I'm hoping that, obviously we'll have another look at this over the summer and as we go, but I'm hoping there will be opportunities for savings in general.
So you know, I know we could do the closings remotely. I don't really want to do that. As you know, I've said that consistently because of the public interest.
No, we're with you on that.
And I'm not sure it would save.
That wouldn't even help that much, really,
Not
doing
really.
them.
It just means everyone can sit in their own homes, or offices. Anyway, so that's one thing. And second thing is that we've got to be out of here by 5. But, I mean, we have been going quite a while. So we've basically got 3 hours, okay? Now, I think we'll just have a sort of 10-minute comfort break in the afternoon, and you can all get yourself a cup of tea or something and bring it in. And we'll have a working, just because it's the last day and, you know, just have to make the most of the time. All right, so should we carry on? Everybody happy? Righty-ho.
Ma'am,
Yes.
sorry, I didn't know whether it'd be worth just touching back on public rights of way. I've got some answers if you wanted them now, or we can deal with them in the notes as you...
I wondered if, on the costings,
Yes.
could you, I mean, is it fairly self-explanatory? Would you be able to do it in a note, or...?
I can certainly do it in a note. What we were proposing, there is a document. We could add it to the Statement of Common Ground,
Yes.
Which is CD 3417 for Prow.
Okay, whatever you think's best.
We could do, that.
Yeah, I mean, there's a couple of Section 106 sessions, and
Exactly, we can always come back to it,
It
can't
seemed we hadn't sort of come wanting to give you the maths and the calculation all at this one, because you're looking at the document and how it works and so on. So forgive us for not providing that.
No, that's all right.
But like the commuted sums on the strategic highways, there's a
Yes.
calculation behind that. There's we can provide it all on a sheet. It would seem to me that's a much easier way with
Yep.
each of these contributions than discussing, you know, the figure and the mechanics, to be honest.
Yes,
When you're short of time.
I think that's absolutely right. So that would be helpful, thank you. Well, we will just touch on commuted sums, because basically commuted sums aren't in here, are they? So
Principle, absolutely. What I was saying is just avoiding the numbers to just
Yeah.
expedite the afternoon.
yes, because we can, as you say, we have got another day, and we have actually had a section 106 ages ago, haven't we? I can't even remember whether we discussed everything or whether we discussed parts of it, but I think we went through quite a lot. We had a whole day on it. So it might be that, you know, if we've got time to sort of try and just really think about it, we might be able to get it done in another day. I don't know, but it just seems a bit unlikely at this stage. Anyway, Right, that would be helpful. Thank you very much. So going back, transport review group, I'm going to come to in just a minute. So if you can just hang fire on that for a sec. So just on the definitions, travel plans, do you, so that's on page 41, do you think that travel plans should also include the site-wide travel plan in the definition? Don't mind who speaks on that. Page 41, there's a definition of what travel plans mean and approved travel plans, one of which is the site-wide one, isn't it? So should that not be included, is what I'm saying? Summers?
I'm just considering where that would have implications. So it would mean that we would be doing an annual travel plan review of that travel plan as well.
Well, that's the point. Yeah. Maybe it shouldn't be then. Don't know.
So, I mean, obviously the occupiers' travel plans and the framework travel plans are documents that get prepared in accordance with the overarching strategy. So they, to a certain extent, they replace it. You set the framework and it says this is how the site's going to operate. These are the travel plans that you've got to come forward with. They've got to cover this, that and the other. And then you come up with the frameworks and they're the ones that you actually implement and monitor. That's how I certainly understood it working.
I think that's why we drafted it as we did, and we didn't have that set out in the definition of travel plan. Yeah, I agree.
So basically what you're saying is once the framework travel plans have been drafted and approved, then there won't be any need for the site-wide ones. Is that right?
Yes.
But of course they are, the frameworks are done on phases, aren't they? So it will just be, you know, the last phase will obviously, it will still be relevant until the last phase, won't it? But
yes.
Okay, well that's fine then.
Can I ask a question?
Yeah.
Sorry, slightly before that, travel information packs. It's just.
Oh yes.
It says to be provided to occupiers of the development. Is that everyone, not just the first one? And assume the onus is on whatever the estate management vehicle is. Because what happens is every time a house changes hands, they don't necessarily get a copy of that. And the same if it's rented. Presumably this is a pack that's sent out reasonably frequently.
I think it's usually only the first ones, isn't it? But I don't know.
But
I mean, you wouldn't do it in perpetuity, would you?
well, if you've got an estate management vehicle that's collecting service charges, they will have a change of, where there's a change of control of that household, as who's responsible for paying the service charge. I can't see why there's a problem with the service charge vehicle providing that. If we're making this a sustainable development, we need to make sure all the occupiers understand this. Thank you.
Yeah.
Well, my initial responses are that it would be unusual. The usual process is that it just goes to the first occupiers, but also at the moment, having not seen it before, I would struggle to see how it could be enforced or monitored over in perpetuity, because once a unit has been sold, obviously the developer's in control of the first sales of houses and can provide an information pack, but thereafter it's private sales down a chain, which the developer would not have any control over unless they were the landlord. But that's just my initial thoughts on it. We'd not thought about it more
So
than
you've
that.
never come across them before?
Well, not obligations to provide it to
Oh, I see.
to occupiers down the line. Yeah, so
okay.
where I've seen it, it's always been to the first occupiers for those reasons.
So
Yes.
if I can comment on that.
Yeah.
So I hear you, but this is what's happening at the moment, and it doesn't work, quite frankly, because you have the first occupier, and then they flip it out 2 years later, and then the second doesn't know anything about this sort of stuff. So there will be service charges on this estate because they're going to have communal areas. And my understanding is they're not going to be handed over all the internal estate roads, etc. So they will be liable to a service charge, and therefore part of the estate management company for this, the vehicle, can do that.
I think, notwithstanding the point raised by KCC over the enforceability, we could tie what Ms Bonnie's saying into this in a way, if there was because this could just be all online, and then that information is available, so it's quite a simple solution that we could deal with. It might not need to be a specific clause, it could just be something that refers to this information being available electronically or something as well, because then that would obviously be easy to be read by anyone who is a new occupant, but also available to others, and it would be very easy to make that available. So I think there's a way through that we could just draft in that is pretty simple, and would cover the concern of the locals.
So sorry, how would you do it then?
I think because we can make that information that's available in those packs available online, so we have to come up to the detail of that, but it doesn't seem that difficult. I was looking at the Kings Hill. There's a Kings Hill web page, for instance, for the whole place of Kings Hill, and that has quite a lot of information on it, including stuff about the management company, but also about what shops are available in the local centres, the employers. It wouldn't be hard to put this kind of level of information in there. So I think it's quite a simple solution, even if it sounds complicated from a drafting point of view.
I have seen this before.
It's a good idea, yeah.
I haven't seen it. No. I've certainly seen and used that approach on tower blocks like tall buildings in London.
Yeah.
And there is actually like a residents' website that they can sign up to, and it has the travel plan information and all sorts of other things that if the lift breaks down or whatever. So I've seen it on an individual building basis, and I imagine while this isn't the same sort of scenario, you could have websites for different phases or different, Oakwood Village or...
Well, I mean, we haven't even looked at the stewardship vehicle, and I think, I mean, it would be, I would have thought it would be tied in with that. I mean, I will want to look into that, something that's quite important, so a good idea, yeah.
Could I just give one example? The Barbican in London does exactly that, and it was a multi-site development, so very, very similar to your one, and it was done over 10 years, and they had it originally in print, they put it online, and it's there for everyone to access, and works so simply.
Yeah.
Really simply.
Okay. Well, there might need to be something on here then to... Yeah. Right, okay, fine. Thank you very much. Right. Yes, the travel plan monitoring fee. Again, can that... I presume that's Kent County Council, Mr Young? Could you add that to your list of how it's... Well, we haven't even got one here at the moment, but I would imagine that there's a standard way that it's addressed.
We'll do, even if it's really simple, we'll do a calculation for every single sum we're seeking.
Thank you. Right, good. Thank you very much.
Could I ask, sorry, on that?
Yeah.
Because that feeds into the travel review group, doesn't it? The travel plan. I'm just wondering if the council, Swale Borough Council, gets anything for that because they're obliged to be party to that on a regular basis.
Sorry, if the council get part of the monitoring fee?
Yeah, because they're part of the review group. Yeah.
I see. Okay.
I think the definition of travel plan monitoring fee does refer to the councils, county councils, and the TRGs costs. Yeah.
Right, let's get on to... Let's now address the travel plan... Oh, sorry, the travel... review group. Hang on a minute. Find it. Where are we? Lost it now. Transport review group. So we've got a clause which tells you what it is. I can guess what you're going to say, Miss Bonnie. I think the parish council should be on it. So that's one thing, and then it's the terms of reference. So, I mean, when I've looked at, I've had this sort of thing before. It was tied up with the stewardship vehicle, and so that they were sort of included as well. Somebody from, or one or more, and that can include community, someone from, well, whoever makes up. It depends how it's done, really, doesn't it? But somebody from the development, basically, which is quite useful, I think, probably. But I don't know how this is going to work. This one. So is that what you're going to say, that you think with the review group that the parish councils or somebody ought to be on it?
Yes, exactly. Took words right out of my mouth, thank you. But the other one is then that flows from that. There are a number of parties, and if it's a review group, presumably it comes to a conclusion, and how's that voted on, who's got majority, etc., and the rights around that. Now, it might be too explicit for this, but I think we need to understand that. And as you say, it would normally be in the stewardship vehicle, there should be some interplay.
It does say there's a dispute clause, isn't there, on this, if people don't agree. I don't know, down to you, really. Somebody, one of the lawyers, I would think, probably. Don't know who wants to deal with it.
I think it may or may not be something for the stewardship vehicle. I don't know if we're in a position to tie that down now. I mean, it could be. It depends on the scope.
Sorry, we haven't seen the draft, so can't comment.
Well, it depends if it is a land. Is that what you're thinking of?
I was going to say, I wouldn't want to put this into the stewardship vehicle, because if we worked with the Land Trust or English Estates or something like that, I wouldn't want to predispose that they would then take responsibility for a transport review group. I think they could be very separate things.
It depends what they're going to be managing, doesn't it?
It does, yeah. But if it was entwined with it within the 106, it would mean it had to happen. Whereas if they're separate, it does allow for that opportunity. It could be them or it could be someone else.
Perhaps the county council's sort of overarching comment on this is that, well, whilst it might be helpful or not to have a group to comprise the reviewing, ultimately on matters of transport, it's the county council that decides what should be done.
Okay. So you mean you have the final vote?
Yes.
Basically.
After due consideration of all.
So what do you think about having any community representation on the review group? Could it not be a bit useful, do you think, or not?
We do try to be constructive, you know.
I'm not suggesting it. Well,
I think that just looking at the terms of reference of the Transport Review Group, it is supposed to be undertaking quite a technical role in commenting on travel plan annual reviews and effectiveness of measures undertaken to mitigate impacts of the development. So I think it's felt that the appropriate personnel are already adequately catered for.
So the voice of experience here is like just locating bus stops, for instance. We've had that with the Stones Farm development in Bapchild. It took an age, but it wasn't till the people with some local knowledge got involved to show that the practicalities didn't work. So I think it's valuable input. We wouldn't want you running down the road doing something that we perceived, and I say we, so it should be encompassing the new community and existing, because this is to integrate the two, isn't it? This is sustainable development.
I mean, you don't want it too big, that's the only thing.
Absolutely not. But you don't need loads of, you know, I'm not suggesting an army of people, I'm suggesting one or two.
I think it's similar to the discussion we had earlier about consulting with the local community. I think this is concerning matters of technical approval under the 106 agreement, for which this group of experts is designed to be convened, and the borough council is again able to call upon community input should it consider that appropriate. But we feel that for the purposes of the 106 agreement, it's appropriately scoped as it is in the agreement.
Okay. We obviously don't agree, so yes, Mr. Dyson.
It is worth noting that the current borough and Kent County Council structures will probably not be in existence in 3 years' time.
That's him.
And they will, and I know it's covered already in the document, but it's worth noting that the current structures won't be here. So we'll have one unitary authority, which may be so big that it can't talk to, or not can't, but has a number of things on its plate that its focus is elsewhere. Just an observation.
You've got a comment on that?
Well, I don't know. I think our collective view is the same as we said. We don't have a issue in principle with a local consultation or input, but it's got to be limited to the extent of numbers. So it can't be the review can't be a sort of room full of people all with differing opinions. It should be, at the moment, it's one representative of each party that are comprised in the review group, and it's that sort of small focus group that we've had envisaged to date being set up.
And it might just be relevant to touch on the role of the travel plan coordinator, who sits on the transport review group, and we've identified their duties in the definition of travel plan coordinator duties, and they are the primary and single point of contact for travel plan matters and for travel issues for the site. So there is a point of contact who could receive comments from the local community and take those forward to the transport review group on which they form a part.
That's a point, isn't it?
Yes, just a bit convoluted.
Well, okay, well, I have to think about that. Yeah. Okay. So, but there's more to say about the because we've got the actual covenants. So page 43 tells us a bit more about what they're going to do and how long they're going to be in existence again. So they're only going to be in existence for, this is the same point really, but maybe different, I don't know, 2 years after the development's complete. But they are dealing with, I mean, the travel plan for the last phase will go on for 5 years after the completion, won't it? So there could be a bit of a disconnect there.
I think we could take that away and agree an appropriate extension, because that's a fair point.
I mean, I think that I would have thought, they've got an important role to play, as I've said already, especially in relation to monitoring and the travel plan and all the rest of it. That really, I would have thought a 5-year period would be better, personally.
We will update that accordingly. We had a discussion at lunchtime on that point.
Okay. anything more on that? Now, the travel plan coordinator, so we've got that in clause 5. Again, I think personally that, I mean, basically, their duties go on until a year after the final completion, do they? I think. Sure. That doesn't seem very long to me. I would have thought really you need, I think it needs to be lined up. Thank you. I mean, in this development, I suppose it's okay to have one, but in the other development, the southern one, you've only got one person that's a travel plan coordinator for 7,000 odd houses. Seems an awfully big job. I would have thought really you need to think about having more than one. I mean, you've got three villages if you talk of Highsted North as a separate one.
It's often a company and they normally do that over multiple sites, but I think we can check that wording, coordinator or generators. I don't know.
Mm-hmm. Just a thought.
Yeah.
Okay. Thank you. Let's carry on. Yeah, overarching. Overarching sustainable transport strategy. I was a bit uncertain, not sure where it is, as to when that would need to be submitted and approved. Not sure where it is now. Oh, here we are. Do we have a date? Probably in there somewhere.
It's paragraph 3, ma'am.
Sorry?
Page 42, paragraph 3.
Oh, I see. Prior to commencement, right. Right, okay, fine, thank you. Right, okay, we've done that. We've done that. Offsite highway works. Could you just tell me, I'm sure there's again a provision somewhere for their timings. Offsite highway works. When they're to be.
That's proposed to be established through the Highway Works scheme, which, per lim A of the definition of Highway Works scheme, refers to the programme for delivery of the proposed highway works in respect of a particular phase or phases.
Thank you. We've done the Sittingbourne station. Right, okay. Nothing else on that one then? Has anybody else got anything on the northern side?
Yes, so we have a substantial point, and it relates to both. I think we've been talking all the way through this as to first occupation, and that for the communities in terms of delivering like the major road infrastructure, so we're talking the Northern Relief Road and Southern Relief Road, causes us an enormous problem.
What do you mean it can't be?
Because potentially we've got not just the construction of the road infrastructure, but we've got this enabling works for parcels of land. Then when they're enabled, and there could be several going on at once, you can have the build out going on, and all of that will be reliant on the existing local road network, including our country lanes. And if I talk about what's happened in Rodmersham in the last week, we've had City Fibre just close a little road.
Sorry, had
City Fibre, a contractor, but actually we had KCC who accidentally closed both roads into the village. And we were entirely reliant on Bottles Lane to serve the village. So I had to phone up KCC hotline, who took note of the issue and said, oh yes, we'll put it in the system. I said, no, you won't. You'll get someone out on site because it is a public health hazard that 2 of the roads into the village are closed. We've got a primary school, a pub, a village shop and other things, and we're reliant on a single track road. Now, a lot of these rural lanes are single track, and we're going to have quite major, heavy construction traffic going along it. And to have first occupation, and this seems to have drifted through viability from first occupation into, you know, how much construction is going on during this, however long you think this initial period is, to build the roads, the Northern Relief Road and the Southern Relief Road. And we are really concerned about the impact on the existing communities and the road network, particularly the conservation areas and our Grade 1 listed church in Romsham, but this extends into Tong, this extends into Linstead, Milstead, all the way through. The consequence here could be dire. And I know it's down to phasing, but we have just heard, I think, earlier this morning that we've got new plans coming to accommodate this, and we need to think about it in the round. But we have to put it out there that this is a very big issue for our villages and for the 5 parishes group, and I believe also for the action group, is the concern of so much traffic being reliant on those small roads and the existing network.
So you're saying before the strategic infrastructure is completed,
yeah,
then how basically are construction vehicles going to access the site?
Absolutely.
For the plots and also, I suppose, for the actual construction work.
Absolutely, the haul roads, and that's why I was quite jumpy about the access points, because they may not be for the new road infrastructure, but are they access points that might be used for haul roads, or could there be other access points? So I think it's fully understanding that, but also I can't see, or we can't see, should I say, the mitigation for that.
Right, does anybody want to...
I think, and sorry if I may, if this was just a highways project, we were dealing with just the construction traffic for highways, but this is highways traffic and potentially commercial, residential and other traffic to serve other things that are within the section 106, etc. So it has quite a wide-ranging implication.
Well, it's traffic to serve the construction, isn't it? It's construction traffic, because you can't have anybody living there until the whole thing's built out.
And no commercial and no other things.
When you say commercial, what do you mean?
Commercial space. First occupation is just on dwellings, or first occupation on commercial,
on everything, isn't it?
and retail and NHS and schools and all of the rest.
Yeah, it's first occupation on everything as far as I understand it. But
Can I just assist as well? Again, these are things that we've considered in the planning conditions as well. So again, I know we're not talking about those today because we haven't got enough time, but there will be a construction and environmental management plan site-wide, and that will consider things like the routing of construction traffic, timing of deliveries, signage, construction phasing as well, so how it all works in a coordinated way.
What I'd like as well is a mechanism for the communities when things go wrong. So this week, or last week, sorry, when we had the 2 roads closed, we were dependent on hanging off the line of KCC to get through to an officer to try and get escalated. And in the end, I had to threaten I was going to call the police, which is unsatisfactory. So that is not great. But the other thing is that City Fibre cut off the power and then 2 days later cut off the internet. So as you can see, that might have been a 1-day issue, but there was a 1-week closure on one road has caused our village chaos.
yeah, I know, I can imagine. There is a provision in that construction environmental management plan, I think, for things like points of contact, isn't there?
Yes, ma'am.
People
There
who've
is.
got issues.
It's partly because I circulated the conditions very late, like
Yeah.
this morning. Councillor Bonney won't have had an opportunity to look at them. But yes, there's as Mr. Bashforth said, there's a site-wide construction environmental management plan. One of the requirements is procedures for maintaining good public relations, including complaint management procedures, community consultation liaison, and so forth. Further condition around construction traffic management plan. Just looking through. So you sort of got like the site-wide, and then construction traffic, and then the construction environmental management plan for the individual phases.
There should be a routing, a lorry routing.
Yes, there is, and that's within the construction traffic management plan, which covers routing of construction and delivery vehicles, parking, turning areas, timing of deliveries, wheel washing, traffic management, signage, construction, details of the phasing. So I think part of it's covered in the conditions. I just don't think we're going to get to the conditions today, and I can only apologise for the late circulation.
No. Well, I mean, that's just an amendment to what we've had before, I think. But yeah, we will be discussing all that. But that is a.
Thank you. There was one word that was in both the north and south S106, and that was the word substantially built before first occupation. And the word substantially, I don't understand. I'm being naive here for a second, but I don't understand the definition of substantially. Yeah. Does it mean it's complete except a few signposts, or does it mean it's? Are we missing yellow lines, or what does substantially mean in terms of the northern and south relief road complete?
It has quite a specific meaning in a highways context. So in a section 278 agreement, there is provision for a certificate of substantial completion to be issued, which is when, for all intents and purposes, the works have completed. But what that then triggers is a maintenance period during which the developer is responsible for maintaining the road at their costs, remedying any defects, and only at the conclusion of that maintenance period is the road adopted, and then a final certificate is issued. So it sounds like a generic term, but actually it does have a specific meaning in a highways context.
Could I maybe suggest you actually just insert that thing as defined by section 278 or whatever, but you give it for the layperson who then looks at a later date, it defines it.
Yes, I take your point. Let's think about how we word that precisely. It doesn't have a specific defined meaning in the legislation.
It does. What did you say?
No, your question.
Yeah, I think we can
put your mic on. I'm sorry.
Sorry, I thought I finished speaking. I think we can work with Kent County Council to ensure that we put some clarificatory wording in.
And that would be most appreciated. It's just giving a little bit of clarity. So how long's a piece of string?
Just to say, we have an existing definition of substantially complete on page 30 of the agreement, but we can add to that if necessary. It does refer to issue of certificate pursuant to a highways agreement, but we can add to that if we need to.
I think that does what I was hoping it did. So, that's fine.
But you could add to that to say where the clause is, couldn't you? Okay, good. All right. Right, should we see how we can get on with the southern one? Yes, so everyone's happy with...
Would it be helpful if...
One tiny point. When we talked about
Go first.
bus contributions, can I just check they were index linked, weren't they?
Yeah,
They are, yes.
Yeah. I think all the contributions are index linked, aren't they?
Yeah, they are. Is it helpful that we can confirm for this what we've discussed on the north we can pick up for the south, perhaps to save time? So some of those points we can carry through?
Yeah, just tell me, because I've gone through them separately, but yes, by all means, if it's the same issue. Right.
Ma'am, I had that you wanted the Network Rail contributions, the calculation itself and the splits and the logic between them, and we would revisit those and come back to you. The KCC to provide a justification for the bus contribution and the 5 years, 10 years, and why it's 220,000.
Hold on. Are you going? Oh, sorry. Didn't realise you were doing that. Right.
Sorry.
Okay, so you're picking up on all the things that have got to be done, are you?
I was just to confirm and let me know if I've missed something.
Okay, so just start again.
Network rail calculations. And we were going to revisit the logic between Teynham contribution and the Northern application and so forth.
Yep.
Bus contribution, how it's calculated, how you get to the 220,000 and why the 5 years or 10 years, or did Mr Wild answer that satisfactorily in terms of the 5 years, 10 years?
He did answer it actually. I think it's more the calculation.
Just the calculation?
Yeah.
The public rights of way calculation, or has that been given to you now?
No, I think that was going to be included in Mr Finch's note, wasn't it?
So how it's calculated and how it's split between the sites?
Well, certainly in relation to the Charles III path, anyway.
And the last one I had is the travel plan monitoring fee calculation. That's all I had noted. Just if you could confirm if I've missed anything.
Yeah, and there were a few other things that were going to be looked at. For example, about the travel plan information pack. Just that point about the definition, you know, could that be made clearer? About travel plan coordinator, that lines up in terms of time, that sort of thing. Yeah. Right. Should we turn then to the southern site and see how we can get on? Right, okay. First of all, clause 6, which is, hang on a minute, where am I? Oh yeah, here we are. Oh no, we're not. Hold on. Gosh, where was that? Where's... oh, what's it? Definition of master developer, maybe. Yes, sorry. The definition of master developer on page 6. So I thought we were told that the master developer comprised Quinn and the landowner, i.e. the promoter and the landowner. Is that not right? That's not reflected in the definition, is it? I know, no, I'm waiting for what you were going to say.
It's just in terms of structuring, isn't it?
Yeah, I think that that discussion came about after we had the discussions on the drafting in the 106 agreement, and I think it has a few implications for the 106 drafting, which I think we need to take away and consider further, because there's obligations placed on the master developer, and if that were to also comprise the owners, the current drafting becomes somewhat unclear in terms of...
Does it?
It's to do with the obligations that we've been discussing with Kent County Council about the role of the master developer as coordinating and overseeing a number of the contributions and other clauses.
Yeah.
So if they're combined into a single definition at that point, it then becomes more problematic later in the agreement. So it's something we've been discussing internally, also with Kent County Council about the ramifications and the implications of a change at that point.
Yes, and you're missing in these schedules the drafting that accompanies that. We had only really put in the front-end drafting to assist with the highway schedule, so you haven't got before you what you have in the separate 106 as we submitted yesterday, but you haven't got before you now the drafting around this master developer coordination role that we've recently been liaising with Kent County Council on. So it's somewhat difficult to extract it from that discussion and consider what the implications of adding the owner into that definition would be without thinking that through in a bit more detail.
Well, I don't really know what you're talking about, but
no. I'm sure
because I obviously don't have a clue what these discussions are about. But
yes.
All I'm saying is that when we were talking about master developer, that what we were told was it was going to be the promoter, i.e. Quinn, and the landowner a joint role, as it were. But if that's different, then, you know,
it
so
can,
be it. But then
it can be a joint role, but it's whether in the 106 they're defined as one and the same. I think that's the issue we're dealing with, and I think we might need to
landowner isn't the promoter, though, is it?
They're not. No, the landowner's
specific here to what?
Exactly. That's the issue.
Mum, I think so. The section 106 obviously binds the land, so binds all of the owners and their interest in the land. Quinn, as promoter of the development, only has a very limited interest in the site, but he's obviously taking in that role with the landowners to deliver the development. One of the concerns that we had is that obviously the site is currently in disparate ownership.
Yeah.
And we were keen to have a single point of contact to ensure a coordinated delivery of the development. And as it stands, the party that can fulfill that role would be Quinn as promoter. So clause 6 and the schedule that you haven't got is about ensuring that Quinn as promoter are bound into that coordination role.
I see.
So clause 6 specifically includes some obligations to ensure that Quinn as promoter are bound by the agreement contractually, notwithstanding that they've only got a limited legal interest in the land. But it also anticipates that Quinn themselves as an entity might in the future divest that role to another party. So there is provision for, you know, another entity in the future to step into their role if they enter into a direct deed of covenant saying that they'll comply with those master developer obligations.
What? So there might be a number of master developers.
Only one at a time. Only one at a time. So there would always be a single point of contact ensuring delivery. Now, ultimately, all of the obligations in the agreement are enforceable against the owners. That's the backstop. But there's this provision in the agreement to ensure that there's this single point of contact coordinating and ensuring that the various submissions are done in a joined up way, that they're not coming from various different people.
Right.
But as time passes, it might be that somebody else needs to step into that role in the future, in which case they enter into a direct deed of covenant with the councils and say we are now taking forward the development.
Understand.
And Quinn falls away.
Okay, thank you. So there is going to be another schedule then in here, is there? Yes. Yes? Another schedule? Okay. Thank you. Okay, Okay, next one. Next one, query I've got. Right, 9.2, which is on page 14. Well, I'm sure it'll be picked up, but it's actually not subject to clause 7, it's subject to clause 6, but no doubt that's because clauses have changed over time, but in this document it's clause 6 anyway. Yeah? It should be 6, not 7. I expect it's probably changed. I think, shouldn't it? Is that right?
Yeah, you're quite right. There are, because there's various versions.
Yeah.
Running right. Yeah, you're quite right.
Just picking it up because I'd hate it to end up in the final document being correct. So, anyway, but more to the point, can you just explain this clause? What happens to any breaches then of the deed if an owner sells their share of the land? So who would be responsible then? If that owner had breached in some way?
Yes.
And it says, I think specifically, that anybody buying that interest wouldn't be liable. So who is? Doesn't it?
No, I think that what it says is, I'm just double checking, but I believe it says is that it's the usual clause that says that when a party parts with their interest in the land, that they are then free of the obligations in the agreement unless there's a subsisting breach that they have caused.
Right, okay.
But the Section 106 agreement obviously automatically runs with the land, i.e. it will bind any incoming owner, and so then they would then be the owner for the purposes of the agreement, or and they would be liable for the obligations in the agreement.
Yeah, but they wouldn't be liable for the breach of the previous owner.
Yes, they would.
Would they?
They would, yes.
So
As would the previous owner if they'd caused it.
they both would.
Yes.
I mean, presumably the new owner, if they did their due diligence properly, wouldn't buy it with a breach on it.
That's how it's supposed to work, yeah. Yeah.
Okay, thank you. That clears that one up. Thank you very much. Clause 26 here refers to the... Sorry, this is the same point probably as the Riverdale land, but... And we did cover this, but I can't remember what it was. Where is the Panton land? Is it 26? No.
It's to the north of...
oh, 25, sorry.
It's to the north of Ruins Barn Road, but we can bring the plan up. That's probably the most
yes,
helpful thing.
please.
It's the site where the school's being delivered, I think.
Where would I see it again?
The inquiry documents, I'm just finding the reference number. 100 point...
Inquiry documents, is it?
Yeah, it should be. We had the title overlays produced north and south.
Mm-hmm. Is it in our file?
100.25.1.
It might be in our file, is it?
Yes, 100.25.1.4.
Oh, it's there, is it? Doesn't say so, does it?
Just double check it's...
The school, right, I see, okay. So just looking at the plan.
So it's...
Sorry, what
Land parcel 16.
What was the plan again? Sorry.
125.1.4, I think.
Right,
So this will slow.
Oh yes. Okay, thank you very much. That's fine, thank you. Okay, right, page 32 was the next one. Was it page 32? Was it clause 32? No, not clause, page 32 it was, I think. Oh yes, so 2.14.4 there was a suggested insertion, wasn't there, that construction vehicles could be allowed to use the link road before it's actually open for use, I think. Is that right? Is that what was being asked?
Yes, that's right.
I don't know if anyone's seen that. Would seem reasonable to me, but I don't know if anyone's. I mean, when the county council adopts a road, does it take a long time after construction, after it's been constructed? Is it a long process or?
Ma'am, it very much depends on how quickly the developer gets on with any snagging lists to complete any do any remedial works after the year's maintenance, after the substantial completion of the development. We heard about the certificate being issued for substantial completion, and then that triggers the year maintenance. So one would hope it would be done fairly quickly after the year, but it can go on longer.
Can I ask a question on that?
Yeah.
So we could have it substantially complete. You've not yet fully adopted it. What are the risks of issues being found between that, in that 12-month period, and then you having to either deal with it, close it, or reshape bits of it? Because obviously that's the risk to the community in terms of how that's accessed and the impact on the local road network. And I say this because outside Sittingbourne train station, when that was redesigned, and it had to be redesigned because it didn't stand up, and I think got redesigned more than once. It went live, I think part of it, and there were issues around the sign-off of that, and that went on for a while. And I'm just concerned that that then has a ramification, elsewhere on the network.
Okay.
Well, I think it might be different where we're working in a brownfield site in terms of construction. I think what Councillor Bonney's referring to was working on live highway, where it's a bit more tricky, and I suppose there's more opportunities for different interfaces with construction works, so you can't do it all in one big hit, but it's very much dependent on what the conditions are at the time. But the standard timescale is one year for the faults to show up.
So if I may, we've got connections onto the A2 here. It's quite complex. You know, we've got the interplay of archaeology and all that other good stuff as well in the background. But this particularly, if there is an issue with the connection and the connectivity onto the A2, this could have a fairly profound effect.
Well, I think in the early days, after it's first built, there's not going to be a lot of occupation on the development site itself. So I'm not sure the impact would be that great as has been suggested.
So the rediversion when parts of the A2 are closed is enormous. The loop round for traffic if you can't access the A2, and if not, you're going to send it onto our rural roads. So that means you're going to redirect traffic through Faversham onto the M2 and down and back into Sittingbourne and out, etc. So this is quite an impact that needs to be considered here, and the risk.
But that's before it's completed, isn't it? I mean, that would be while it's being constructed you're talking about.
I'm worried about defects, Mum.
But
that's a defects period.
Yeah, is the occupation though once all that's been sorted out, or is it?
Well, therein lies the rub, I think.
Well, I don't know. It must be. It must be in the agreement.
Because substantially complete is when you can start using it, and the defects period is after, isn't it? Or have I got that wrong?
So highway agreements, 38 agreements, it's a two-stage process. So you enter into agreement, there's a bond up front and all the rest of it. Developer carries out the works, and when there's a first stage certificate, call it what you have, first stage certificate, substantial of completion or whatever it is, it then goes on maintenance for 12 months. That's the period in which if there's any defects or anything, that's the developer's responsibility to fix. If there's a default, the agreement allows, this is standard agreements, I haven't actually looked at Kent's agreements, but standard agreements allow step-in rights, so you can call, that's why we have bonds, you can call upon the bond if there's a default, and only once the defects and all of that is remedied, it then becomes adopted.
So really occupation shouldn't be precluded by the issue of that final certificate, because there's already security under the highways agreement to ensure that process is followed through and defects are remedied. For the purposes of occupation, it's sufficient that it's open to traffic, because that's what's that's what's prohibiting.
So I've claimed on a bond before, and it's quite a convoluted process, but I'm not worried about who's financially at risk there. I'm more concerned about the practicality of if an issue is found, then that reroutes, we've got all these occupations coming on board, and say calamity, something happens under a roundabout or, whatever, then all that traffic that should go along the new route won't be able to, and it will be funneled onto the local road network.
Anybody want to take that one up? Or maybe, we haven't got Mr. Wild still.
I just don't think it's. I don't think it's for the drafting. I think it's.
Yeah, there's nothing much more that can be added. It's actually, it's really for Alan. What happens in practice? That's the structure of the agreement. If there's a default, I don't know what time periods are allowed. I don't know what the time periods are allowed, but the process is if there's a defect, either the developer sorts it out or the council will sort it out, and there might be a notice provision in the agreement that gives you, like I said, I haven't seen Kent's one, but that's how generally these sorts of agreements operate. Alan, did you have anything to add?
No, you're right. There's a bond in place that would deal with defects if they occur and the developer hasn't carried them out. But I suppose the issue here is when that happens, if there is a defect. But the standard practice is it's a 12 months maintenance period. You would hope that and the Highway Authority are confident that defects will show up within that period. That's why the 12 months is applied.
I think probably the issue here is that as to when occupation is allowed, and therefore traffic from the people can basically use the road from the houses, and I suppose the problem is that if there are defects that come up on the road that means it has to be closed, then all the traffic from the houses will have to go onto local roads. That's what it's getting at, I think.
I suppose the question is there a default mechanism? I sounded a bit like a broken record, but what you're going to allow is a continuous occupation of houses when you know you've got a road structure, possibly with an issue.
It's all secured through the highways agreement.
But we've got in this agreement section 106, which is the trigger for the house building, isn't it? And first occupation. Yeah. So if there is an issue with the road, you're going to continue to allow the occupations of properties exacerbating an issue.
Well, yeah.
Where's the default?
So I suppose one way to look at this might be that, just to break it down, obviously before you enter into the section 278-38 agreement, you go through a very detailed design phase with a safety audit aligned to that. You then have exacting obligations to construct the road with the correct materials, etc. You have rights of inspection throughout for the county council, including rights to open up the road, check materials, check construction. At the end of that, you have a detailed inspection and certification. And if the road has not been built to the standards, so the agreement will include, not only those detailed drawings, designs, construction standards, construction methodology. If it's not been built to that standard, it won't get certified as complete. The road cannot be open to traffic. The sort of defects that we're talking about in the defects period, of course you can't rule out any eventuality, but the sort of defects that hopefully by that point you're getting to are minor defects, cracks that might occur, but really I think that sort of defect is the defect that might arise through use. Yeah. So if you just left a road open for a year, nobody using it, it would just be fine, and you'd have the same problem. So you've got to subject it to some use for sort of cracks and settling and so forth to arise, and that's why you have this maintenance period. Developer comes back at the end, makes it good. I mean, clearly if there's some major defect, something has gone seriously awry, so it's not how it's supposed to work, but that's why the agreement's in place. That's why it has all those controls in place to ensure that it. But of course, that's how it's supposed to.
Perhaps it would give some comfort, Mr. Millard. I mean, in this annual period, this yearly period, in your experience, do the defects generally result in, just minor inconvenience, or do they result in road closure and problems like that? I suppose that's really what it comes down to.
I mean, it's probably one more for my colleagues in the agreements team that deal with this on a daily basis rather than on the planning side. But I've not come across myself situations where there's been road closures to that extent that would disadvantage people for more than a short period of time that's dealt with in the normal street works, traffic management. So I can't envisage that there's going to be a major problem with anything through the remedial side of things that needs doing.
I mean, have you got experience of that, Bonnie? I mean, has that happened? Are you thinking of a particular issue?
Well, I'm just thinking what we have is no halt mechanism, so that's fine if the world is good. But, you know, tunnels do fall down, things happen. And I just don't want to be in a position where this development continues when there is a live issue and the local authorities and the county council have no ability to break it, as in put a brake on saying you can't have any more occupation until this is resolved.
Can I just perhaps offer this? You've heard from Mr. Millard, we've got, in his experience, we've got no evidence of that type of problem. We will check with his colleagues in the relevant departments. Kent is obviously a very large organisation, and we'll check to see if there's any evidence of any substantial problems. I'm going to resist the temptation to explain why we might not have had any problems. But I think I understand what Councillor Bonney's saying, but you know, everything that is included in the the procedures that have just been described by Mr. Simpson is all designed to make sure this doesn't happen. You know, this is England, and we do generally make sure that these problems don't occur. We'll double check though, so that you've got evidence from the right people at Kent to confirm that this isn't a problem and doesn't occur on in their experience as the highway authority.
Yeah, that will be helpful. I think that will at least go. I know you could never say never.
And just one further, I just had one further point of reassurance. The highways agreement is going to include the provision of security, and that security will not be released until the final certificate has been issued.
Yes, but it still doesn't resolve the problem.
Well, there's an incentive for the developer because the security won't be released until such time as that final certificate is issued.
No, but there might be a financial penalty, but it doesn't stop the problem of the road being closed. But anyway, I think that would be very useful, Mr. Young. I mean, you can never guarantee every eventuality. All you can do is look at, whether it's a reasonable possibility, I think, probably. Okay, thank you very much. Right, let's carry on then. Okay, thank you. So, Schedule 2 then is my next bit, I think. Yep. Now, I've got the same thing about bus contributions, so we're already going to have a note about that, aren't we? So, from Kent County Council, yes. Thank you. Thank you. Framework travel plan. I'm just wondering if this is the same thing. So the framework travel plan in this case, it would be the same thing, would it? That would be you'd have a site-wide travel plan, and then you'd have the frameworks for the phases, and then you'd have the individual occupiers' travel plans. Is that right? Same thing.
Same proposals are replicated, yes.
Okay.
Madam, National Highways have a point about a highways agreement, if we're moving on to that
Yes,
next.
I'm coming to that next. Let's just get that up then. Highway agreement. Yes, let me just see what I wanted to ask. Yes, okay, off you go.
Yes, so I think given that it's been clarified that the on-site highway works don't include the motorway junction, we don't see any need to be included in this definition of highway agreement. If you go through to the obligation in paragraph 9, that actually refers only to agreements with the county council. And in any event, the sections 10 and 16 of the Highway Act don't deal with highway agreements. That's highways consent. So if the applicant thinks we need to be in this definition, then we'd like to understand why, but we can't currently see why that's the case. We don't think we need to be included in this definition of highway agreement.
I don't think the applicants are saying that, are they? Or are they?
I think we had agreed with the point made on the Northern Agreement, and the same applies here. I think the in consultation with National Highways was added by National Highways, but that was probably predicated on the basis of the definition of highway agreement, including with National Highways as well. So I think if we remove
Page 33.
National Highways from the definition of highway agreement, then that same principle is agreed on both.
Yes, I mean, you can't really require National Highways to do anything, can you, unless they're party to the agreement. So they would have to come out, wouldn't they? I think, wouldn't they?
I think the only provisions that relate to National Highways involvement in the 106 agreement are requirements on the County Council to consult with National Highways in relation to certain matters, and those references to the matters on which National Highways wish to be consulted were included based on comments from National Highways on this schedule. And there's nothing to prevent them from being consulted under this agreement without there being a party to it, because it's an obligation on the councils to consult with them. There's nothing imposed on them per se.
So just for clarity, the consultation obligations, I think, relate to the transport infrastructure delivery strategy, which is something different to this definition, which deals with highway works. And perhaps it is helpful just to look at the particular obligation which refers to highway agreement. The only other place where highway agreement is referred to is in paragraph 9, highway works.
Yeah.
And that paragraph appears only to deal with agreements with the county council. So National Highways wasn't really clear on why it needed to be included in the definition of highway agreement, since that seems to refer only to highway agreements with the county council.
I thought I saw somewhere in here, and it might have been in the other one, that off-site highway works, the implication was that it did include the junction. I don't know where that is now. Because actually, off-site highway works, if it's to be similar to the northern scheme, doesn't include the Southern Relief Road either, does it?
So the definition of off-site highway works is works to existing adopted public highways outside the land, and the motorway junction is obviously in the red line boundary.
Sorry, oh yes, okay, yeah. Mm-hmm. So, just going to highway agreement then, is there any, does it require National Highways to do something, to enter into an agreement there? Section 10 or 16 of the Highways Act, it will, won't it? To build the new junction?
So, Madam, that's dealt with in the conditions. There's no obligation on that.
Well, there is. It's in the. Doesn't it follow on if it's in highway agreement as definition? Then presumably it's also.
So that's what I meant in terms of highway agreement, where it's dealt with in this document. The only place it's dealt with is in paragraph 9, which only deals with highway works and highway agreements with the county council. There's no reference to National Highways in paragraph 9. And for National Highways part, the matters are all dealt with in the conditions, which refer to the Section 16 consent and the Section 278 agreement that must be entered into before development can commence. That is sufficient for National Highways, and it protects National Highways' position. National Highways will also be involved in terms of agreeing the transport infrastructure delivery strategy, which, as I mentioned, is separate to these highway works, which appear only relate to those the county council will be involved with.
So the delivery strategy, which one's that? Where's that?
It's defined. Yes, there's a definition and then there's an
What
obligation
page
in
is the
relation to it.
definition? Could you just tell me, sorry?
Sorry, it's page 36.
So that doesn't refer to National Highways, though, does it?
That National Highways is then referred to later on, and the transport infrastructure, which is defined on the following page, page 37, includes the new junction 5A of the M2.
Yes, that's where I was seeing it. Yeah. So, transport infrastructure is the isn't that the offsite and on-site highway works? Isn't that what?
It's defined separately. So the on-site and off-site highway works have a separate definition, which I think, as we discussed before, the motorway junction needs to be excluded from that definition.
Of transport infrastructure?
No, of highway works, and then transport infrastructure is defined separately.
So basically, on highway agreement, then it needs to omit reference to national highways there.
Correct.
Right, I see. Okay. So that needs to be changed then. And is there? Did you say there's somewhere else that national highways is referred to?
No, that's the only change that. That's the only change that needs to be made. National Highways is mentioned in relation to. Let me find the.
Oh yes,
the obligation.
Transport infrastructure.
Yeah, so it's obligation 2. And it's just the infrastructure delivery strategy to be submitted to the County Council for written approval in consultation with National Highways in relation to proposals for the new junction 5A.
I mean, is that sufficient?
For National Highways, it's sufficient because of the condition that deals with the Grampian condition, which essentially prevents development from commencing before the Section 16 consent has been obtained and the Section 278 agreement has been entered into.
Okay. Anybody else got anything to say about that? No? Okay. Okay, thank you. Right. Okay. So, I think... Okay, so we've dealt with that then. So is the idea that the Junction 5A, the Southern Relief Road and the Southern Relief Road will be distinct phases? Will they be phases or will they be included as phases?
Yes, they are, madam. They are defined on the phasing plans, but also the conditions define the sort of Grampian conditions as well in terms of those works. So,
but are they phases, strategic phases rather than sub-phases?
They're actually carved out. So actually, they're as a sort of separate part of the planning conditions because they've got separate sort of conditions. They are sort of different requirements, if you like, rather than sort of putting them in the general pot of phases. So,
okay.
Yeah.
Yes. Thank you.
But I think they'll be covered by both. So.
Okay. Yeah, we've got the same thing about the public transport hub. So I think Mr. Wild said we didn't need to have anything on the northern site, but did on the southern site. So this is page 35, and it's to do with the overarching sustainable transport strategy. And I think he explained it was a sort of area where you could have layover buses and stuff like that. But that will be in the southern site, as I understand it, would it? Anything else to say about that? Okay. So the pedestrian cycle routes, which are, you can have a strategy for providing them, and how are they? So a lot of some of those are off-site, aren't they? So how they won't be able to be delivered through reserve matters, will they? So how are they going to be delivered? I suppose I wanted to know.
Is there as well, because on the north, sorry mum, sorry, the element surprise there.
Yeah.
On the north, we obviously talked about these off-site junction works around similar areas, and then these ones in the south. I'm not sure how much differentiation there is between, because they would just sort of give it a global name of Woodstock Road.
Which one? What are you looking at?
Because on the north, we discussed on the north, some of these works would need to be done for the north application, but
yes,
but they absolutely, it's imperative for the south that they've got to be completed. But also, are we talking just about junction improvements for the one that applies to the north, or are we talking about the whole sustainable stuff that applies to the south as well as to the north?
Well, are they not listed somewhere?
It
Is
just
that
gives
not
Woodstock
the,
roadworks.
Transport infrastructure, access junctions on page 37, is that what they are? Is that not right?
I think that for the purposes of the 106 agreement, when we're referring to the pedestrian and cycle routes, we're referring to those that are being delivered on site as part of the development.
I think we're talking about two different things here, actually.
Okay.
Weren't we? I think you're talking about junctions, I'm talking about the cycle route.
Well, no, because the cycle routes run along Woodstock Road.
Yes.
And they're off-site. We were
Yes,
talking about
but
off-site, weren't we?
Sorry, I thought we were talking about the off-site junctions.
Yeah, but the north application referred to those, so I'm just trying to clarify between the two applications, but also the extent of the works and their definitions.
I think Mr. Wild said the northern application, Woodstock Road works, were just to do with junction improvements, not for the cycle improvements, which are linked into the corridor on the southern scheme.
Does that answer your question? Or not?
I don't think it's completely clear, to be honest.
Are you worried about where these, that it doesn't define where the cycle routes are? Is that what you're saying?
Sorry. Partly, and also to make sure that how defined they are and across the two agreements, there's no confusion, because we're going to have a series of officers looking over this over an extended period of time, and I'm worried that things will slip. And I suppose this goes back to, you know, it'd be quite nice if we could have a diagram, flow diagram of what's got to come first, an explanation in this that we could hang off.
Well, as far as the cycle routes, have we got some sort of overall we've got the overarching sustainable transport strategy, haven't we? I mean, it is true that they are divided into north and south, aren't they? So I suppose it is a legitimate question to ask, given that if the south would go ahead, it's going to be in connection with the north, whether there is a sort of any linkage between the two to make sure that they actually tie up together.
I think. Sorry. I think that the idea is that would be dealt with by the overarching sustainable transport strategy for each site, because just looking at that definition, we refer there at limb D, this is in the southern one, to a site-wide strategy for the delivery of the pedestrian and cycle routes, including off-site pedestrian and cycle improvements. So there is an acknowledgement that travel strategy has to consider the off-site improvements, but that would coordinate with the sustainable overarching transport strategy secured in respect of the northern scheme. So that's the big picture, really. But of course, because there are two separate agreements, we do have one separate document for each one, but they would marry up, I think, would be the intention, and consider the wider.
I suppose the question is, do they?
We could add a requirement. We could add the definition of the overarching sustainable transport strategy on the southern scheme to cross-reference into the northern scheme, I suppose.
It's some form of terms of reference or something, isn't it? So, because clearly, if both come ahead, you want them to talk to each other and actually come as a complementary way rather than almost sort of almost in isolation, isn't it?
I mean, that's only going to happen. That would only happen if both sites were approved. So we don't have to worry about the south site solus, really.
Yeah, that's right.
Because the south site would only go ahead with the north.
Yeah.
So I think it's quite important to have. You're right. It's quite important to have some sort of overall coordinating.
We can add in some additional text here that requires that meshing together, like Mr. Bashford said.
It may be, as you say, madam, it may be a case of, in the north you need to have that because it's a case of there's two choices there, isn't it? But the south will always come forward as a comprehensive approach, won't it? Because it can only come forward with the north.
Yes,
so, exactly. Yes, so it's possibly some slight change to the drafting in the north to reflect there could be two different...
Well, of course, the north could come forward just on its own.
That's what I'm saying. So if it came forward together, the two need to sort of have...
Yeah, you almost need a third agreement, don't you?
We can cross-reference in both agreements that should X happen, Y happens.
I think that is necessary.
Yeah,
it's relevant on
there
a
could
number
be a
of points.
substantial period of time, effectively. You could enact north, and then, there's for whatever reason, a substantial delay in the south. There's no caveat in there, is there, to say...
No, or it might be that they come together at the same time. Yeah. I mean, we just don't know at this stage.
I do actually think, and I haven't looked at the latest documents on phasing, but I do think that has quite a implication we need to think about on phasing, possibly, and the interaction between the two.
Luckily, that's not a problem for me, is it? I mean, I've got obviously we've got the parameter plans, but apart from the parameter plans, we've got no phasing, have we? Yet, and that will be in the next stage, I guess.
Correct. Yes.
Because the phasing, I don't think it actually puts a time on it, does it? Here in the parameter plans, it doesn't say one's. It doesn't marry them up at all. Yeah.
No.
Should it?
I think that's where the sub-phases come as a kind of you approve them and they've got to be coordinated. So if you had both, it wouldn't be a mess because you'd have the local planning authorities going to approve the sub-phases. So you always have to have regard to what's going on. So it makes a sensible approach at each stage. Take into account the triggers, the...
it's a big job, isn't it?
Master developer model.
Diagram maybe won't be dealing with that.
So the sustainable transport strategy is basically the same for both schemes, and it looks at it as one big whole. So the bus strategy, for example, goes between the north and the south, and they explain how they're going to do that. The cycle component of the sustainable transport strategy deals with both sites in a comprehensive way. And then, so you do have, that's an indicative document, but you've got something that actually thinks through how this would work as a complete piece. When it first started, the applications were actually interlinked. It was only subsequently that the northern application was separated as an individual standalone application.
Yeah.
So that has been thought about, albeit it's indicative, and then layered upon that. So we've got a direction of travel that looks at it as a comprehensive piece from a sustainable transport strategy, and then you've got the requirements for phasing and so forth. So perhaps even if some of these requirements just referred to adherence to the indicative scheme set out in the sustainable transport strategy.
Yes, I mean, they are slightly different, aren't they? I mean, you say they're a piece, but for the north, I think there are slightly different provisions.
I think we're quite comfortable that we can add in some additional wording here that will resolve your concern.
Okay. Right, I suggest we just have 10 minutes where we get maybe a cup of tea or just a comfort break, and then we will go on till 5. It's very warm. Is that all right? It's very warm.
It's very warm.
Yeah. Right, so we'll just adjourn till 20 to 4. Thank you. So, final push. So we do actually have to be completely out of the building by 5:30, okay? So I'm going to carry on till 5, and then everyone's got to get out smartish. Remember, please take all your rubbish with you, all bits and pieces, and please remember to hand in your label things, your security things, okay, everybody? Yep. Right, okay, let's get going then. So, pedestrian and cycle route scheme, page 35. Does someone say that the pedestrian and cycle routes just refer to on-site? Because there are, it might be a point you made. There are some off-site as well, aren't there?
Yes, I think there is a reference to off-site pedestrian and cycle improvements in the definition of overarching sustainable transport strategy, and those would need to be detailed in there. But
hang on a minute. Where?
In Lim D on page 35, the definition of overarching sustainable transport strategy.
Yeah.
There is a reference to the on-site, which is the defined term, and then also off-site along Ruinsbarn Road and Cromer Road.
Yeah, okay. So what about pedestrian cycle routes? It just means on-site then, does it?
Yes, so the definition lower down of pedestrian and cycle routes means those to be delivered as part of the development and determined through reserve matters approvals.
Yes, as part of the development, but as part of the development, I suppose you could say that the off-site ones are going to be delivered as well. I just feel
yes, but I suppose for the purpose of the obligations and the purpose of which we're using that term in here, it flows into the definition of pedestrian and cycle route scheme and the maintenance and management strategy. So this was really all designed to detail the proposals for the on-site, the off-site being dealt with through the sustainable transport strategy. I think it's probably worth looking at them in the connection with the subsequent obligations.
Okay. So these are just the on-site, okay?
They do, of course. They all are the same piece of road. So it's...
Sorry?
They are all the same piece of road. So there's the element that is within the site, and there's the element that continues straight immediately off it. So I'm thinking Highsted Road is one example of that, and Ruinsbarn. So I suppose is there a car crash or a breakdown between the two? What you don't want to end up with is one bit being delivered and not the other. It's got to be continuous.
Anybody want to deal with that?
Yes. That's obvious, yeah. You wouldn't do that, no.
Well, let's wait till we look at the actual strategy, shall we? Because these are just the definitions. Okay. Right. Oh, yes. So just the off-site highway works, and it might be something you actually said, Ms. Bonnie. Should we actually detail them like we have in the northern? I think in the northern section 106. Let's just check.
This is a discussion I've had with Mr. Wild, and unfortunately
Yes.
he's had to leave us, but the off-site highway works for the north are defined, but the south follow the sustainable transport strategy and the work within that strategy. I will get a more detailed answer for you. There's a distinct reason why it's set different between the north and the south.
Right.
I don't want to get it wrong, so I'll ask Mr. Wild to put in a note if we need to. But maybe we can add it as a note to why it's different here. I think it ties in with the monitor and manage approach, so that essentially the extent of the off-site highway works, there will be some that are required no matter what, and there are others that would be required depending on the monitor and manage position.
I see.
But I will find the correct answer for you on that question.
Thank you. Right. Ho? Right, so that's another note. Right, okay, thank you very much. So, yes, now, can we just quickly discuss this commuted sum then, for the management of the new roads? If it is to be provided, it would need to go in, wouldn't it?
Yeah.
Or well, it doesn't. It's not normally something that's covered in a 106 agreement. And we're not going to go into the principles of it for now, but just in the abstract, a commuted sum would not normally be detailed in a 106 agreement. If there is any commuted sum, it will be dealt with in the highways agreement.
Right. Okay.
I agree with Victoria, but there's nothing to stop having a commuted sum.
Sorry?
There's nothing stopping from us securing a commuted sum in the 106 agreement, and given what's being discussed in evidence, I think it's probably should be secured through there.
There's, if I may.
Yes, Mr. Young.
There's clearly a dispute about this. You'll remember the cross-examination focused on whether there was an in-principle objection.
I did remember, yeah.
And it is my understanding that there remains an in-principle objection, albeit that it was included in the sums. But to be honest, it wasn't the clearest answer that might have been provided.
I think the problem is your policy says may. So
sorry, I don't want to cross-examine you. I think I was seeking to just establish what the applicant's position was, not what the policy was. That's a separate issue. But just in this without prejudice session, we're trying to understand what the applicant's case is, and my understanding is that they take an in-principle objection because they say so they don't want to pay it. The reasons are a matter of evidence. So
I thought Mr. Gehring said there wasn't an in-principle, but they were discussing it or something. I might be wrong.
I think we were in a slightly difficult position in that we raised concerns with the view that Kent said that there was an acceptance that commuted sums are payable, and we looked at their own policy, and it didn't say that they were mandatory. It said they may be required, and it gave examples of the provisions where it may be required. And we also had concerns over the sum and the fact that we didn't think it was proportionate.
Yeah, I thought that was
and we
more
hadn't
what
seen,
your concern was rather than...
So we don't know at this point whether Kent County Council will want to take a commuted sum for the strategic roads, will apply their policy, because it's a may policy and that may well be a political decision to be made. So a bit like other issues, we don't know the answer to that.
Okay, so first of all, Mr. Simons said yes, there was an objection in principle.
Okay.
There was an objection to the way in which he thought it was triggered, i.e. what the guidance said, and also an objection to the sum. And that's what I took as their position, and then I cross-examined on that point. And obviously, for the purpose of reporting, it's vitally important that we're absolutely clear on the applicant's position, the applicant's case. As I understand their case, it is to say, well, if you go to its, I'll just give you the reference because you've looked at it several times, but Appendix C, Kent Design Guide.
Oh, yeah.
And when you look at that, there's 4 categories. You have to be a little bit careful how you read that document because the under this category refers to what's above.
Yeah.
And there's a category that says the cost of maintaining features that we consider as extra over items. Examples include home zones, highway structures. You remember the reference to the bridges and surfacing, etc. And it says under this category, the costs that represent an increase in our future maintenance liability that is significantly more than the anticipated normal funding generated by the development. So it isn't the road per se, it's the additional unusual features, including the bridges.
Okay,
so that's the that's what it's predicated on, and you've got that page in there that says background. The applicants have raised various arguments about why they don't think that's applicable. That's a matter for them to explain, but we've had that in terms of cross-examination. They say it may be there was reference to the wider public benefits. Remember that? And they were saying, well, look, we're delivering this road, so we don't think the maintenance payments is appropriate. And they also raised the issue of viability.
Well, let's not go to that again.
No, but you'll note the adept guidance and what was said about that.
But what we need to discuss
Could I make
here,
a suggestion that we meet with KCC and talk about this?
We just finished this now.
Can I just say something before we go off on this? All I wanted to know was, is it to be dealt with in the Section 106?
Yes. Yeah, because there's obviously a dispute about it, and we would like this established.
I think, can we take that away to talk to them about?
Yeah.
Yeah, I think that's
really
if it may end up being because then by doing that it becomes a binary issue potentially over a blue pencil clause,
well, I was just thinking,
which is a risk. Or we may be able to, during cross-examination, Mr. Young also said it would be ring fence, whereas the adept guidance didn't say that. So I think it's fair to say things have moved on. It might be better to take it out of this environment and have a discussion about it.
Yes, I mean, we'll come on to the sum in a minute, if I may, just briefly.
I don't really want to discuss that.
Okay, we've got the calculation for how it was done and the various components in that, but we'll include that in the note of all the others, if that's okay. Because there was an issue about how it's calculated. We can definitely talk about that outside the inquiry. The crucial thing, and it was a perfectly valid point that they made, was, and indeed Mr. Birchall was at pains in his evidence to make this point to you, that actually you won't know what the precise sum is until the final, detail or design of the road. And so we've got figures in there for the purpose of the viability exercise, but the fact is that it is likely to change. So all we're asking for is that the principle of the sum, based on the relevant formula, which can be agreed as a separate document, is included in the Section 106. Then we know we're going to get the commuted sum, because it's obvious, saying it's in the highway agreement, it's obvious that the applicants are taking the view that they don't think it should be paid.
Well, you don't know if you're going to get it because it's subject to the blue pencil clause.
Yeah. And that was my suggestion for the answer. Remember, so I said, look, if they can continue to dispute it on a without prejudice basis, and you or the Secretary of State could decide, I accept their arguments about wider public benefits, and therefore it could be excluded.
Yeah, that seems a good way forward to me.
Yeah.
But I think you need to discuss.
Yeah, I might just add that I think the very reason for which it is, as Bevan Britton agreed, that it doesn't normally feature in a 106 is because it is not normally determined at that time, and it's determined at the time that later on in the programme, when a highways agreement is ready to be entered into and more detail is known.
The trouble is, it's been discussed at length at this inquiry, so the Secretary of State's got to deal with it one way or the other.
Would you need a note that picks up on the policy basis for it being included at this stage as well, Mum?
I think a note just to, whatever.
And I agree with it being included in the Section 106. I think it should be absolutely apparent to all the land what the liabilities potentially are.
Obviously I've cross-examined upon it and I've got the answers that I want. I don't have my learned friend who's got the answers he wants, but if both parties want to put in a note, then that's fine.
Well, after you've discussed things, just say how,
That's what I'm thinking. We have a discussion, we see where we get to, we provide a joint note of something that, and then at least we all know where we are.
Decide to agree, you never know.
We may do, exactly. You never know.
Yeah, if it's
helpful.
It would, wouldn't it?
The basis upon it not being paid is was identified in the adept document as on the basis.
Well, Yeah, okay, thank you. I think that's enough of that. Okay, thank you very much. That's very helpful anyway. Right, okay, can we use that? Public rights of way contribution, same points that we did before. You're going to do me a note about how it's calculated and split between, with the coastal path between the two. Teynham Station contribution, we've already talked about that. Includes. Hang on a moment, what's that about? Transport infrastructure definition. Wait a minute, sorry, just E. Yes. In transport infrastructure definition on page 37, could you just explain to me what, we haven't got Mr. Wild anymore, have we? That improvement works, where I could just find the justification for that in the transport assessment, please.
Yeah, we will get you the reference as quickly as we can. I think it will be the TA, and I think it was volume 5 on the north from memory, so it probably will be the same volume, but I'll just double check.
Will you do that before we, in a minute? Or will you? Right, okay, that's great, thank you. Just don't, right, okay. Transport monitoring period 37. What's that? So that is, yeah, that needs something, doesn't it? Included. Mr. Millard apparently is including that. Are you still here, Mr. Millard? Yes. Says in the notes. Is the transport infrastructure and highway works the same as the transport infrastructure, or is it something different? Anybody help me there?
Sorry, apologies.
37, transport infrastructure and highway works. It might be because it's getting a bit late in the day and we've had a long day, but I'm not sure whether that's the same as what it is. Is it the same as the transport infrastructure?
Sorry, Mum, is that the same point as came up on the Northern Agreement, where we've got the two tiers? We've got the transport infrastructure, which is essentially the strategic works and junctions, and then we've got the highway works, which are the more detailed phase-specific works.
Well, this says transport infrastructure and highway works. Does it mean both then? Is that what it's saying? It looks as if it's one term, that's all. I think we've got that on the...
Sorry, I can't see the...
Page 37.
Page 37.
Transport monitoring report. B. Impacts associated with delivery of the transport infrastructure and highway works. I just wondered what they were.
Oh, yeah. Yes, so they're two separate items. Sorry, it's not one long definition, it's two separate.
Right, okay.
Yeah, so it's the transport infrastructure.
Which is the high level stuff.
Yes, and the highway. Perhaps we should insert a "the" in front of highway works to make it clearer that it's two separate things rather than a sort of combined definition. But yes, it's intended to, so the monitoring covers both the strategic and the phase-specific works.
Can we get the spelling on Cromer's Road right as well, please?
apostrophe S, isn't it?
Put an S on it, chromas.
Has it got apostrophe S or is it just chromas?
Just an S. Just an S. I think it's wrong throughout the inquiry. It's been replicated.
Okay. It's just chromas. Yeah. Thank you. Right, 17. Framework community. I put page 38. Here we've got something called a framework community travel plan.
I think that's an outdated reference to something that is no longer in existence, and it should be the same principle as we've discussed on the north with the...
So that means framework travel plan?
It should just be, that bit deleted and then start with means the framework travel plan.
Oh, right, okay.
Sorry.
Thank you.
And our comments stand on, obviously, what we said on the north is ditto for the south, on travel packs and groups and etc.
Thank you. Yes, this is a travel plan coordinator. This is my point about. Would you think about possibly maybe having one for each village, or?
Can we put coordinator or coordinators?
Yes, I think so.
And then it would be covered by that.
Yeah.
Is that a cost that's being picked up by the applicants?
Well, yeah, they have to. Yeah, I think so. I just think it's an awful lot for one person to do, really.
Well, it might be that for the first few years, because obviously there's more than one village, but there's also the time and the numbers moving up. So it's kind of not village dependent. It might be more of a time dependent factor.
Well, if it's the same person still interested in doing it, I suppose.
It's a long job, isn't it? 20-year job.
Well, yeah. Okay, well, whatever, but think about that. Oh, the monitoring fee, that's the same point as we had before. You're going to provide a note, aren't you? Not you. Yes. Good. How long do I've put here? How long do the travel plans go on for? Is it longer, isn't it? Is it 10 years or something? Or I think it is, isn't it? Monitoring period. Here we are. Oh no. Thought because it's a bigger site, it was longer. Where does it say that anyway?
It's the same as for the northern site.
Yeah, I mean, can you think about that? Because the framework one is I don't know, does it give a time for the framework one in this?
I think there were two separate time frames. So there's 6.1.5, which refers to the time frame for
occupiers,
and framework, which is 5 years from PC, practical completion
of the phase,
of the relevant phase.
And there's also 7.1.1. Sorry, 7.1.1. Item C has got some dates in there as well.
Yeah, I don't quite know what. That says 2 years, doesn't it?
And then it goes on to 5 years later on in the paragraph.
5 years is, you know, for smaller developments, 5 years is fairly standard, but I'm just thinking, big site, would it be, you know, should it be a bit longer than that, do you think?
Just looking at as the ongoing phases are coming forward and then more phases are coming forward, the period of which there'll be overlaps, so you just need to, I'm praising here and have a look.
Well, I mean, you've basically said after completion of the phase, haven't you? So they will be all stopping at different times, won't they? And a development as big as this. In fact, some of the earlier phases will have stopped before the later phases even started.
Exactly, yes.
And the trouble is that...
but they're all collectively provide movements and information and data.
Well, yeah, I mean, the things like the bus, things like the bus, you see, are going to, you know, the proposal is to run from one village, you know, the internal bus, going from one village to the other. So that's going to span different, you know, quite a long period of time. So you don't want to sort of like the travel plan to suddenly be stopped. You know, you need to...
We will have a discussion with Mr. Wild and look at the drafting.
I think you really need to look at these timings and think about what's intended to be done with it, you know, and make it a reasonable length of time. That might be something that we need to come back to, I think. Okie dokes. Right, we're doing really well, aren't we now? Page 39. Transport infrastructure delivery strategy. My comment is 2.1.4. Oh yes, 2.1.4. Should that also include the Northern Relief Road being substantially completed?
Yes, we agree.
No, because the linkage is the other way round. So we've got. Hang on, let me just pause.
It's round the other way. Got to have the northern first, haven't you?
Yeah, but can't I occupy? Can you?
We already deal with that in.
Where?
The other 2.1.4.
In what, sorry?
The 2.1.4 in the previous schedule that we were discussing earlier. Because this agreement itself isn't... The Northern Relief Road isn't transport infrastructure as defined for the Southern Agreement. It's transport infrastructure as defined under the North. We currently do have a linkage, which is in 2.1.4 of the preceding schedule, which we just discussed, but it shouldn't feature in this clause here because this is talking about transport infrastructure being delivered pursuant to this agreement, and this is the agreement that secures the Southern Relief Road. It doesn't secure delivery of the Northern Relief Road, so it's correct as it currently is stated.
Ma'am, within the conditions for the Southern scheme, condition K3, no part of the development hereby permitted shall be occupied until the Sittingbourne Northern Relief Road, as approved under planning application